Court warrant out of the University Lakes Justice Court for a case involving theft, control of property. I'll also appoint you an attorney in that case and set an arraignment hearing in the University Lakes Justice Court on October 7th at 8:30. And then finally, we're here today on 2 probation violation warrants for violating Term 1. I will appoint you an attorney in those 2 cases as well and set a probation revocation arraignment hearing on October 9th at 8:30 in the downtown Superior Court. I am going to issue a secured bond on each of these cases. It's going to be $250 on your new case and each of your probation violations, and then a $100 bond on your Justice Court case. So that's a total bond of $850. If you do post bond, I am going to order that you not possess any weapons, drugs, or alcohol, and you must contact probation within 72 hours of your release. All that's going to be in your paperwork. Do you have any questions? Okay, grab your paperwork to your left and have a seat. Samuel Estrada to the podium, and Memo Martinez to the chair, please. Good morning. May I have your name and date of birth?
Samuel Estrada, 09/13/2002.
Thank you. We are here today on 2 different cases, a Superior Court new case and a Term 1 probation violation. On your new case, you were arrested on allegations of burglary in the 3rd degree, Class 4 felony, and resisting arrest, passive resistance, Class 1 misdemeanor. I will find probable causes to those allegations. I am going to appoint you an attorney in both your new case and your probation case. I am going to set a probation revocation arraignment hearing on October 9th at 8:30, a status conference on October 8th at 8:30, and a preliminary hearing on October 10th at 8:30. All those will be in the downtown Superior Court. I am going to issue a secured bond in the amount of $250 on each case. So that's $500 total. If you do post bond, I am ordering that you not return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness, no weapons, drugs, or alcohol, and you must contact probation within 72 hours of your release. All that's going to be in your paperwork. Do you have any questions?
I do have a question.
What up, Dwayne?
I have a daughter. I just thought I care about and comes to my house where I live at. I'm wondering if I get released on like electronic monitor or something, because I really would hate to not be able to go see my daughter because I don't think I can pay the bill.
What?
So as of this point in time, no, I'm not going to release you on your own recognizance. I would suggest talking with your attorney about those allegations. It's not the court's intent to keep you away from your daughter in this case, but I do have other concerns about this case that prevent me from allowing you to be released on your own recognizance. But talk with your attorney. Your attorney can ask for your release at the next hearing if that's appropriate.
When is my next hearing?
Your next hearing is going to be on the 8th. So that's in 6 days. Okay, grab your paperwork to your left and have a seat.
What up with this kid right here?
Memo Martinez to the podium and Crystal Merritt to the chair, please.
Crystal, come on down to the Price is Wrong. Thank you for the...
Good morning. May I have your name and date of birth?
Memo Martinez, January 10th, 1988.
Thank you. We are here today on 2 different cases, a Superior Court new case and a Term 1 probation violation. On your new case, you were arrested on allegations of narcotic drug possession, Class 4 felony. I will find probable cause on those allegations, and I will appoint you an attorney on both cases. I am going to set a probation revocation arraignment hearing on October 9th at 8:30, a status conference on October 8th at 8:30, and a preliminary hearing on October 10th at 8:30. All of those will be in the downtown Superior Court. I am going to issue a secured bond today in the amount of $250 on each case. So that's $500 total. If you do post bond, I am ordering that you not possess any weapons, drugs, or alcohol, and you must contact probation within 72 hours of your release. All that's going to be in your paperwork. Do you have any questions?
The 500 is, do I have to pay the whole 5?
So it's a secured bond, and it does mean you can go through a bonding company. Typically, they require 10% plus collateral.
Yeah, so a lot of bail bondsmen don't go lower than 1,000. So
you'll have to call them to see what their terms are.
How does that look for you guys?
Okay,
right
grab your paperwork to your left and have a seat.
There we go. Right.
Crystal Merritt to the podium and Corey Griffin to the chair, please.
Crystal, come on down. Perfect. Jenna, all right, cool, Jenna. Thank you for that. Hopefully you guys could hear good. Let me know if you guys could hear good.
Good morning. May I have your name and date of birth?
Crystal Merritt, 7/22/82.
Thank you. We are here today on a probation violation warrant for violating terms 3, 4, and 5 of your probation. I will appoint you an attorney to represent you. I am setting a probation revocation arraignment hearing on October 9th at 8:30. That's in the downtown Superior Court. I am going to issue a secured bond today in the amount of $250. If you do post bond, I'm ordering that you not possess any weapons, drugs, or alcohol, and you must contact probation within 72 hours of your release. All that's going to be in your paperwork. Do you have any questions?
What is 3, 4, and 5?
Essentially, that you haven't maintained communication with probation.
Oh, my probation officer stopped talking to me when I was texting.
Talk with your attorney about that. You
What?
do have the ability to contest these allegations if that's what you choose to do. Your attorney will go over what your options are.
Okay.
Okay. Grab your paperwork to your left and have a seat.
Nothing crazy yet. Nothing.
Corey Griffin to the podium.
Nothing
And
crazy
Johnny
yet.
Gonzalez to the chair, please.
That fuzzy hat has a mind of his own.
Good morning. May I have your name and date of birth?
Corey Griffin, March 12, 1999.
Thank you. We are here today on a Justice Court warrant out of the West Mesa Justice Court for a case involving driving with a suspended license, which is a Class 1 misdemeanor. I will appoint you I'm not appointing you an attorney because they're misdemeanor allegations, but I am setting an arraignment hearing in the West Mesa Justice Court on October 21st at 8:30 a.m. I am going to release you today on your own recognizance. That's a promise to appear at your next court date. As a part of your release, I am ordering that you not possess any drugs without a valid prescription and no driving without a valid driver's license.
Okay.
All that's going to be in your paperwork. Do you have any questions?
No, sir.
Okay, grab your paperwork to your left and have a seat.
Thank you.
Johnny Gonzalez to the podium.
That thing was on me.
Good morning. May I have your name and date of birth?
Good morning, Johnny Gonzalez, 2091.
Thank you. We are here today on a Superior Court new case. You were arrested on allegations of narcotic drug possession, Class 4 felony. I will find probable cause and I will appoint you an attorney. I am setting a status conference on October 16th at 8:30 and a preliminary hearing on October 20th at 8:30, both in the downtown Superior Court.
Yes, sir.
I am going to release you today on your own recognizance. That's a promise to appear at your next court date.
Yes, sir.
As a part of your release, I am ordering that you not possess any weapons, no drugs without a valid prescription, and no contacting the arresting officers.
Yes,
All
sir.
that's going to be in your paperwork. Do you have any questions?
No, can I say something?
If you'd like to, sure.
Yeah, see, I didn't even know they were in my pants.
What?
I brought some clothes to somebody, they threw me in, and it was just a mess.
So talk with your attorney about
Those
any
weren't his
potential
pants?
defenses today. I'm not going to hold you on this. Just
Yes,
make sure
sir.
you get to your next court
Did
date.
he say that wasn't his pants?
Grab your paperwork to your left and have a seat.
Thank you.
The final matters on the calendar for Ronald Saavedra, number 22, 23, and 24 on the calendar today. I was provided information from MCSO that he is a danger to himself, so I will go ahead and conduct his initial appearance at his cell. We're here today on 2 grand jury warrants and an arrest warrant. On the arrest warrant, number 22, he was charged with 2 counts of theft obtained by misrepresentation, Class 5 felony. I will appoint an attorney on all 3 matters, set a status conference on October 8th at 8:30, preliminary hearing on October 10th at 8:30, and I will issue a secured bond in the amount of $500 on his arrest warrant. For number 23, a grand jury warrant charged with 1 count of aggravated taking the identity of another, Class 3 felony, forgery, Class 4 felony, and theft obtained by misrepresentation, Class 4 felony. I will appoint an attorney, set an arraignment hearing on October 9th at 8:30, and issue a secured bond in the amount of $5,000. Finally, number 24, another grand jury warrant. He was charged with allegations of trafficking stolen property, Class 2 felony, fraudulent schemes, Class 2 felony, theft of means of transportation, Class 3 felony, theft control of property, Class 3 felony, 2 counts of aggravated taking the identity of another, Class 3 felony, 1 count of theft of means of transportation, Class 3 felony, 2 counts of taking the identity of another, Class 4 felony, 1 count of forgery, Class 4 felony, 1 count of burglary, Class 4 felony, 4 counts of forgery, Class 4 felonies, and 1 count of theft obtained by misrepresentation, Class 5 felony. I will appoint an attorney, set the same arraignment hearing on October 9th at 8:30, and affirm the bond in the warrants, a $100,000 secured bond. I will conduct his initial appearance at his cell and provide him with a written copy of all of these orders. If I do need to make any modifications or changes, I will do so either on the record or in writing. That does conclude the 8 a.m. calendar. We will stand in recess until 11 a.m.
Naomi, thank you for that. Hey, hold up, guys. Don't go anywhere. It's nice and early right now where I could jump into a different court right now. So we're going to go ahead and get into it, if you will. As soon as I fix this screen over here, I can't even see what's going on. Here we go. Hold on, let me see. Where are we going to be going today? Where shall we be going today? Let me see. YouTube. But Your Honor, I'm rich. Let's see.
Yeah.
Died D-I-E or D-Y-E?
Yeah.
They're just died.
Let's check out what's going on. Let me see. Docket El Paso. Ooh, let's go to this one.
Okay. Thank you, Mr. Perez.
Yes, ma'am. right now, I'm gonna put in each one at $2,500, and then,
Can you guys hear the
once you get a referral
lawyer?
from the 346, we'll let perhaps, if he doesn't post the bonds on all his cases, and you get a referral from the 346, we'll revisit the issues at that point in time. Thank you.
Here we go.
All right, so on these two cases
There,
that
that's better,
we're
right?
a total of basically 19,000 in bonds, they went down 5,000 in total, okay? But however, the other one's at 15. I cannot touch that one until Judge Vaca gives us permission to hear it. She'll automatically, she'll send it over here, but it's just a matter of how quickly she sends us the referral. Your attorney will know what to do, sir. Thank you.
Thank you.
Okay, thank you.
Good, sir. Hey, sir?
All right, guys, just give me a moment here. I'm just setting here. Oh, damn. That's his real hair. Hey, what up? What up, Aaron? How's it going? Let me see right here. All right, there. You guys can see now, right? Okay, cool. You guys can see.
What's your name, sir?
Anthony Hightower.
Last name?
Hightower.
Hightower.
Say it again, please. No louder.
Hightower.
Hightower, got it. Oh, yes, Mr. Hightower. He's here on a charge on a PR bond revocation of a charge of possession of controlled substance, penalty group 1, less than a gram, with a $1,500 bond. The permanent attorney is the public defender's office. This morning, Ms. Quevedo from that office is going to represent you. She's going to try to convince me to lower your bond. Then I'm going to hear from the prosecutor, then I'll make my decision. Go ahead, Ms. Quevedo. Basically, the allegation is he never reported, okay? Go ahead, Ms. Quevedo.
Thank you, Judge. Mr. Hightower, why was it that you never reported to court, to the PR bond officer?
Well, I was trying, but the person whose phone I was using, I don't know what happened to them or where they went or whatever. And so I was unable to be able to keep calling, and it was hard for me to find anyone else that would lend me their phone so I could call the office.
That's a
Do you
damn
have
lie.
a phone number now?
No, I don't.
Phones are so
I don't.
prevalent
Okay,
nowadays.
so how would you go about reporting if the judge were to release you again?
I know someone who's out, I know someone right now that has a phone that would most definitely let me get in contact.
Hey, phones now are like water and air and internet. Everybody has
Waco.
them. They're so plentiful out there in the calles. Now in prison might be a different story.
Okay, and how? I'm sorry. So were you brought on a warrant?
Yeah.
Judge, was he brought on an FFJ, on a wanted person? I'm sorry.
I cannot tell you. I don't know. I don't know for sure. Do you live in Waco, Texas?
No. I live on Waco Street.
Okay. No. Okay, it's here.
Yeah. I'm sorry, my bad.
Okay. Thank you, Judge. Mr. Hightower, who do you live with at that address?
My mom.
Okay, and your mother doesn't have a phone?
No, she does now. She does now. She has a number I can use now.
Do you need to go to a shelter?
No.
How long have you lived in El Paso?
About 4 years.
Are you a U.S. citizen?
Yeah.
Do you work?
Not yet, no.
He's in jail. What do you mean does he work?
Do you feel like you need any mental health or substance abuse services?
No, man.
Do you have, let's see, access to transportation in case you're required to report in person?
Yeah.
And to come to court as well?
Yes.
Can you guys hear me good?
Your Honor, based on the information provided, we're requesting another PR bond or any relief the court might find fitting. Thank you.
Ms. Calhoun, apart from this case, is any priors?
No, Your Honor.
Okay.
All right, cool. Thank you, Naomi. Thank you, Sabrina.
Ms. Rivera, what can you tell me?
And Angelica.
Yes, Judge. So he was placed under enhanced supervision level July 3rd of this year for the possession of controlled substance, and he did fail to report since being released, and we did try to contact him at the number he provided, but we were unsuccessful.
Okay, thank you. What level of supervision did we put him out on last time?
Enhanced, Judge.
I'm a quitter also.
All right. This is your last shot, okay? It's on you to call. The fact that you better find a phone to call or come in or whatever. Actually, no, I'm just gonna make it reporting person every week, okay?
Damn, there it is, reporting.
So you
He's
must
not gonna have no
report to Piabana every
transportation.
week. The day they tell you to report and the time they tell you to report, now when you feel like reporting. 2, cannot be rearrested for any new offenses. You're not allowed to possess or consume illegal drugs or alcohol, and when you report, they're gonna be testing you. Hope you understand that. It's on you to report.
So
they're not your babysitters, they're not your mommy, okay? Because otherwise, I mean, this is your liberty here. You want to sit here in jail? We'll be glad to keep you here.
Keep him.
Understood?
Yes, sir.
Thank you.
Yes, sir. How long do you give him before he
Your
violates?
Honor, there's one of the defendants here that wants to ask you a question.
By all means.
And Judge, I'm sorry, really quickly. I think we already did both the Spanish speakers, no?
No.
No? Oh, okay,
Canada.
sorry.
What up, Bree?
What is your name, sir?
Yeah, I'm better, sir.
What's your question, sir?
I was just trying to clarify which ones were reduced.
Basically, the one that was at 10,500, the other one was at 7,500. Those are reduced to $2,500 each. The ones at 15,000, I cannot touch it yet until Judge Baca gives me permission.
Okay.
I'll adjust from this court, okay?
Oh, what the
Okay, and that would take like a day or two, or
It depends how quickly your attorney, Mr. Salas, gets the referral and try and set it for a bond reduction here, sir. That's about all I can tell you right now.
okay. So those 2 charges are now down.
Basically, now you have 5,000 on those 2,
helmet.
and you got 15 on the others. Your total bonds are now at 20.
20,000 in total.
Yes.
Okay, thank you, sir. Thank you, Your Honor.
Your Honor, I'm gonna switch floor. Do you want me to go to the Spanish speaker?
Oh, yeah, who's
Santillanes.
Diabolical.
What's the Mr.
Judge Santillanes,
Okay, thank you.
It's funny
Okay,
till I get it.
Short recess.
Oh, yeah. Oh, there. We passed it along. See, we're going to give it to the judge now. Ay. Did he say we're going to take a recess? Is that what I heard? No? Okay. This is El Paso, I believe.
Yes. Intensive.
What up, Bulldogs Forever? Rowdy, what up, Rowdy? Tune in his I work to do nothing. Judge likes his hat. Ay. Oh, okay, there. All right, so we're switching over right now. All right, hold up. I'm gonna switch over to something else. Let me see. Playlist. Oops, not playlist. My subscriptions. Let's see who's on right now. Oh, this fool. Oh,
I have been asked to extradite you to the state of Minnesota. It appears that Minnesota is requesting that you be extradited to Sherburne County for failing to appear for your probation violation hearing. This is a body-only warrant. Do you understand that you have the right to have an attorney? You would have the right to have your attorney contest this, or you can contest it on your own. But do you understand that you also have the right to voluntarily agree to be extradited to the state of Minnesota, Sherburne County?
Do.
You do? All right. Now, I have here signed copies of the affidavit for the waiver of extradition, and it appears that this is your signature. Is this your signature?
Yeah.
Do you wish to be voluntarily extradited to the state of Minnesota?
Yeah, well, I was wondering if I fought extradition and I lost, right? Which is, does the time here still count towards?
I am not able to give you any legal advice. I can tell you what the law says. You are on a signature bond, so no, this time will not count.
Oh,
what up, Eric?
Oh, I'm on a signature bond right now?
For me, yes.
Yeah, but not for Anoka because I have a warrant.
No, in Anoka,
sorry.
Well, that's not Anoka. This is Sherburne that's asking for you.
Yeah, I meant Sherburne. I'm sorry.
Yeah. So I do have these affidavits with you with your signature. Do you wish to voluntarily be extradited to the state of Minnesota?
Yeah.
Has anyone made any threats or any promises to you for you to voluntarily extradite?
No.
All right. So I'm signing these affidavits. You will be extradited to the state of Minnesota as soon as practically possible. Thank you, Mr. Burke.
Do they, I got a question. Do they have a certain amount of time to come?
Oh, damn. She just cut that fool off. She said later. See, you wouldn't want to be.
Hello.
Hello, Your Honor.
Oh, I'm still on.
Yeah, you are. All right, let's. I guess we're gonna be going somewhere else now, guys. That one was Wisconsin, the one we're just at right now. Hey, thank you, Queen Bee, for the follow. Let's see if Judge Boyd is on.
Yes.
Okay. Thank you, ma'am.
You're welcome.
All right, Boyd is on.
All right. Anyone else ready?
Yes, ma'am. Page 3 at the bottom, Mr. Antonio.
Here we go.
Damian Antonio.
Judge.
All right. Let me, if Mr. Antonio, if you'll come up.
He's right here. He's coming up.
Good morning.
Morning, ma'am.
James,
and counsel, you're currently in trial with us.
I believe so.
All right, what I'm going to do is I'm going to recall this for October 30th for discovery. Are you here, counsel, or no?
Oh, let me check. I should be.
Minnesota sometime.
No gum joy.
There's so many crazies.
Don't swallow
She
it.
Gators,
they would
Chad.
always tell us that would ruin your intestines. Is that true? Who knows?
No.
But we never did.
Yeah, I can be here on the 30th because I got a final consult just down the hall on a trial case. So we'll
All
be
right,
here.
so we're going to recall you on October 30th.
cool,
That's
Naomi.
for discovery to make sure that your attorney has all of the information. All right, once you sign the reset form, you are excused. Thank you. Thank you for dressing appropriately.
Oh,
for
we can't
court.
even see that guy. We can't even see that guy because that guy's hat is blocking his face.
Science.
Okay, all right.
I talked to the state. I think we can come to
We'll
a
see.
conclusion.
We'll see what happens.
Yeah.
You don't like that hat.
Good to know, bud.
On Damian Antonio, could you do one for discovery for October 30th? Thank you so much.
Leg's doing a lot better. I iced it for 4.5 hours last night.
He got
So
egg
it's-
on his head.
Well, it's coming down slowly.
I can't imagine.
Being off is the most important now. I need to just sit and elevate.
Man, who would have thought that these filters would be so fun?
Come on, buddy. Yeah, that's the booth.
I'm sorry. Let me do this real quick.
Hey, Royal,
I'm
thank
writing
you.
you now.
Oh, you're fine.
He likes the noodle for sure. Sopa. Damn, if he only knew, if this dude only knew.
Thank you.
Oh no, my guy got the
Another one ready for you to work.
noodle
Oh, I'm ready.
on his
I
head.
have Jeffrey Dollar, please read you down.
Let's see what else we got here.
Jeffrey Dollar.
Present, Judge. Morning, Judge.
Good morning. Okay, I was telling everybody about our Scotland trip with Virginia, where we were in Scotland, and Hannah said, Stephanie, where's the castle has been known to be haunted, and you're staying in the most haunted room. And so I was telling my story. People like, no, that's not true. I'm like, ask Hannah, it's true.
I would have moved. I don't do ghosts.
All right, so today is the plea deadline date.
So, Judge, the plea deadline was actually last week, and you had recalled it for today. There is a PF case that was filed while he was out on bond.
All right, everyone, please whisper. Yes.
It's an engaging or organized crime case. And so Melissa contacted intake to try to get the file, because if we're going to work something out, we'd like to work him out on both cases. He's habitual. There's a sizable offer on the first case. What I'd ask the court to do is give us 30 days so we can try to get both cases worked out at the same time.
All right, Melissa. On this case, do you all actually have the discovery on the engaging in organized crime?
I don't know how much
Don't lie, Boyd.
is involved in that case. It's with our intake prosecutor. I emailed her the same day that we were set. I asked her to look into it. She's not gotten back to me. I know, just based on what Mr. Maurer and I have discussed as far as the facts of the case, the allegations, I imagine that it is quite voluminous. So I don't know how quickly she's going to be able to get it together. I can make him an offer on the case that we have indicted. If
You did. There's already one on file.
But I don't know how much faster I can get her to get the ball rolling on
And as far as the plea bargain, I mean, we're not in a position to reject it. I just would like to be able to resolve both cases at the same time, because I think the other case is going to be pretty significant based upon what at least I've read.
All right, so I'm going to recall it for November 6th. There will be no further extensions.
I'll send another email.
Right. Thank you, Judge.
All right, is there anything else?
No, that's it. Thank you.
All right, thank you for for dressing appropriately for court. Once you sign the reset form, you will be excused.
Damn, this bear had definitely attacked everybody.
Judge, he's got a job right now, and we were trying to see if we can get him switched from, you on partial?
I'm on full house.
He's on full house arrest, to see if we can get him switched to.
You need to confer with the
Yeah,
state.
I'll talk to him. Good. Yeah, let's see if I'll come talk to him. November 6th.
What hat do you guys like the best? The rainbow.
And
I
sir,
like the rainbow one, but it
Mr.
blocks
Farris,
everybody.
we're just waiting for certain paperwork, and then your attorney will zoom in to speak with you.
Damn, everybody has one.
It's Mr. Dollar. The state agreed to partial GPS for work. If I think I have a copy of the motion, if I could.
Oh, do you have the motion?
The rainbow fro.
Give that to me.
Yeah, 1:30, Judge.
All right, see you then.
Anything, text or call if we need to take anything up beforehand.
Awesome. And we do have an ice pack in the freezer.
I appreciate you.
All
I'm gonna go ice it at Amy's office right now.
Okay, all right, thank you.
How many of you guys like Judge Boyd? Let me ask you guys. It's 8:51.
My short arms.
Do you guys want to stay here, or do you guys want to go to Pima County in 9
favorite
minutes?
was
Pima County is
The
going to
Grease
start
trip
at
where Rachel and Hannah
at
sped
9.
off and
Yeah.
left
And I will tell you, when you were saying, Stephanie's in charge, listen to her. I told them not to touch those
We
cats.
got one for Pima.
I'm like, keep your hand. You don't know where those cats have been. They were feral cats.
Did you go on the grease trip where Virginia tried to smuggle the soil back in she had to put it in they have like some dump for
Patrick, thank you.
agricultural stuff, and she brought I think Trey was 8. She brought him like a 2-foot dagger.
Yeah,
I'm like,
yes. I was like, Virginia, I don't know if that's a good
not
idea.
a good idea.
But I said it'll be interesting to see what happens, Jess.
Hey, Deborah, thank you. All right, I'm gonna check at 9 o'clock when the court starts. If it's not that slow-mo, the sloth judge will switch on over.
See that the clerks will need that.
Yes, ma'am.
All right.
Quick question, if I could.
Yes.
Pre-trial diversion.
Mhm.
Do I get a reset or how do I do it?
Yes. Are you ready?
What we're gonna do, we get fill an application today.
Okay. All right. So once you're ready to approach on it, just let me know.
After you do, I need to get the application first, or I'm ready to get a reset right now.
Oh, if you'll talk to the clerk and they'll sign you in.
Okay. Yeah.
Mhm. And Adriana, let me know if there's anyone else ready.
Yes, ma'am, not at this moment.
Thank you.
Why is he doing the orange still here? His court probably hasn't started yet. Is that a lawyer? The dude in orange, that was in jail. The lady or the woman on the left hand side, the upper left, that's the judge, Judge Boyd. On the right hand side, normally that's where the lawyers and the defendants come up. If that makes any sense. Ay, ay, ay. That dude right there walking up, yeah, that dude. Let me see. I gotta see him right now. Judge looks annoyed. Hey, Annie, thank you for that. Let me see. It's 8:54. This judge is moving too slow for me right now. I need something that's gonna keep pushing a lot quicker. So.
Your Honor, I'm not sure if Miss Jada Nixon has been spoken to yet or.
De trabajo del acusado y de sus compañeros de trabajo.
He expressed that dissatisfaction.
Él expresó que estaba insatisfecho.
In exchange, the defendant confronted the victim.
A cambio de eso, el acusado confrontó a la víctima.
Throwing a nail gun at the victim, striking him in the forehead.
A nail gun?
Tirando una pistola de clavos a la víctima, golpeándole en la frente.
Causing a bleeding laceration.
Y causando una laceración con sangre.
These assertions by the victim were corroborated by the 2 witnesses on scene.
Estas afirmaciones por la víctima fueron corroboradas por los 2 testigos en la escena.
Candidly, Judge, I do not have an updated criminal history given the age of this case. My history is fairly stale.
Básicamente o francamente, señoría, no tengo antecedentes penales debido a que este caso es antiguo. En cuanto a los antecedentes, no tengo mucha información.
At the time of filing, it appeared that he had a 2022 DUI case.
En el momento que se tramitó este caso, parecía que él en el 2022 tenía un caso del DUI.
Yet pretrial risks him at a moderate risk at a level 7.
Los riesgos previos al juicio le puso en un riesgo moderado en un 7.
Due to his criminal history.
Debido a sus antecedentes penales.
The warrant issued in this case initially was for
Hey, Paula, I'm gonna have to start the stream over
bondable.
again. I'll be
La
right back.
orden de arresto se emitió primero, en este caso, por $3,000 que se pueden pagar con garantía.
The court services report indicates the defendant's intention and ability to pay that.
Los servicios del tribunal indican la intención del acusado de pagar eso.
Given the allegations of violence, Judge, I believe that ongoing bail of $3,000 is appropriate.
Dadas las alegaciones de la violencia, su señoría, yo creo que $3,000 es apropiada.
Should he be released, I'm asking conditions that he obey all laws.
Si le dejan salir, pido condiciones de que obedezca todas las leyes.
Consume no alcohol or drugs.
No consuma ni alcohol ni drogas.
And have absolutely no contact with the alleged victim.
Y que no tenga ningún contacto en absoluto con la supuesta víctima.
His name is Primitivo.
Su nombre es Primitivo.
Amaparo.
Amaparo.
Imparo.
Emparo.
Thank you, Judge.
Gracias, juez.
Thank you. And before I turn my attention to Ms. Wellborn, Ms. Gianoli, are you asking for any testing on that no drugs and alcohol, or just if he's found to be intoxicated, it's a violation of the court's order?
Señora, ya no le está pidiendo pruebas en cuanto a drogas o alcohol, o solamente si está intoxicado o embriagado es ahí cuando le arrestan.
Judge, I saw no allegations of any use of substances in the report.
Yo no vi ninguna alegación de uso de sustancias en el informe.
Likewise, court services notes a 0 with regard to substance abuse in the past 10 years.
Los servicios del tribunal indican un 0 en cuanto a uso de sustancia en los últimos 10 años.
So I didn't see a good faith basis to seek testing, Judge.
Okay,
no veo una fase en buena fe para solicitar las pruebas, juez. Gracias.
Given the proximity of the DUI charge, I was on the fence about whether monitoring officially would be warranted, but I'm inclined to go over what you're seeking. Ms. Wellborn.
Entonces, debido a la cercanía del DUI, no sabía si se necesitaba monitorización. Pero, señora Wellborn.
Your Honor, I had a conversation with my client this morning.
Su señoría, yo he tenido una conversación con mi cliente hoy a la mañana.
He has some other legal matters and holds at the jail.
Tiene otros asuntos legales y otras retenciones en la cárcel.
I share Ms. Gianolia's thoughts that his family does intend to pay under the interim bail setting if they haven't done so already.
Y comparto las intenciones de la señora Gianoli de que la familia quería pagar la fianza si no lo han hecho ya.
Hey, what up, Carl?
So on that basis, we submit.
Con esa base queda presentado.
Thank you. I do find that the city has met by clear and convincing evidence that monetary bail is warranted and find that the $3,000 bondable is sufficient.
Veo que la Fiscalía ha demostrado por pruebas claras y convincentes que se necesita una fianza más allá de las retenciones no monetarias. $3,000 sería suficiente.
And I will adopt the recommended conditions of the city. If you are able to secure release, you will obey all laws, consume no drugs or alcohol, and you will have no contact with the alleged victim in this case, that being Primitivo Ceja Amparo.
Entonces, sigo las recomendaciones de la Fiscalía. Si es que usted le dejan salir, señor, tiene que obedecer todas las leyes. No puede tomar ni drogas ni alcohol y tiene una orden de alejamiento de no contacto con Primitivo Ceja Amparo.
Sorry. Anything further in this matter?
¿Algo más en este asunto?
Not from the city, Your Honor.
¿No de la Fiscalía?
All right, that'll conclude this hearing and we can proceed to the next matter. Thank you.
Eso será todo. Concluimos esto. Pasamos al siguiente asunto. Gracias. Thank you.
That takes us to Kyle Gilstrap, I believe.
Well, she's a native Spanish speaker. The interpreter, she's from Spain. So, yeah, she's the real deal.
He was here to talk to the attorney earlier, and he had to be taken back.
If you will.
Okay, understood. We'll pick it up at the end of the docket.
Okay. Okay, we can address that then.
Yeah, I'll take all of the end of dockets at once. Angela Paschetti, please.
Your Honor, she spoke to Ms. Wellborn. But
hey, how is everybody doing today? Hopefully you guys are doing good.
Okay, we'll pick her up at the end of docket as well. Then I think that concludes Reds, and I will be looking for Stephanie Bennington, please.
Hey, Katie, thank you for the likes. Nicole, gracias. Hey, how are you doing?
Good morning, ma'am. How are you feeling today?
I'm sore.
All right, sore, hanging in there. I got you. All right. We are here in an arraignment in 25 CR 14662 Looks like the allegation is disturbing the peace as a breach of peace in violation of NRS 203.010. At the beginning of these proceedings, did you have a chance to speak to Ms. Wellborn, the attorney, today?
Court.
Yes, sir.
Did you have your rights explained to you? Do you understand these? Feel you understand these proceedings, your options today?
Yes, sir.
All right, let me turn my attention to Ms. Wellborn. Ms. Wellborn.
My client intends to enter a plea of not guilty today, Your Honor.
All right, then Ms. Bennington, for the record, to the charge of disturbing the peace, breach of peace, how do you plead today?
Not guilty.
Not guilty? Okay, I'll take a not guilty plea. Let's discuss conditions of potential release. Let me hear from the city first, please.
Thank you, Your Honor. Here's reported domestic disturbance. It appears the defendant had called 911. When law enforcement arrived, she indicated that she and her ex had just been arguing, verbal only. It appears that the parties were in a prior dating relationship. They have 2 children in common. When they were speaking with the victim, he was a bit perplexed as to why they were called on that date. However, he had indicated 4 days earlier that there was an altercation in which the defendant had punched him in the nose. She apparently had observed him trying to communicate with an ex-girlfriend. This angered her. He showed law enforcement a date-stamped photograph of him having some injury and some blood to his nose.
Damn. She gave him straight to the
You wanna
nose.
give me
One
just a
shot,
moment,
one
if
hitter
I may?
Of
quitter.
course, please.
Hey, what up, Slime?
I'm sorry, Judge. I have the wrong case. I
Yeah.
apologize for
Back
that.
on the
This is another.
Okay, hold on.
I'm sorry.
No,
Hold
no,
on a minute. I have the wrong case here, Judge. I apologize for this. This was a reported domestic disturbance by nearby patrons who indicated that
DA, get it
females and males
together.
were screaming at one another. The victim indicated that he had driven his ex-girlfriend home, indicated to her that there were some belongings, some packages inside the home. He then told her that those packages were not there. It sounds
Trish,
like
thank
that was
you.
where the argument had escalated. The victim had some injuries to his person, the victim had some injuries, as did the defendant. The defendant indicated that the father, as well as the victim, had dragged her out of the apartment complex. There were 2 individuals who had reported this incident, indicated that the defendant had pushed the victim. And there was a variety of stories, frankly. The victim had a couple different
No wonder she
stories.
has a bag
From what I
opener
was
on
able to gather, there looks like there
liar.
was some mutual combat related here, hence the reason I filed the disturbing the peace. Your Honor, I do have some concerns given the defendant's criminal history. It's about 41 pages in length. It's concerning to the city.
Okay.
However, also given the allegations, Judge, I don't believe that a domestic battery could be proven here, hence
Okay.
for this reduction in charges. I'm not opposed to her OR release given the filing decision that I made here. I would ask for conditions upon her release that she obey all laws, consume no alcohol or drugs, and have absolutely no contact
Hey,
with the
Joel,
alleged
thank you
victim.
for that daily heart.
Again,
I
I'm not
appreciate you.
seeking for any sort of enhanced supervision or testing, as there's no indication that she was impaired on this incident.
Excellent. Thank you very much. Ms. Wellborn?
We submit, Your Honor.
I presumed as much. I think that is a reasonable approach. I will allow her to be released on her own recognizance, subject to the conditions of obey all laws, strictly consume no drugs or alcohol. I need you to understand that my no drugs, no alcohol order includes the use of marijuana. So just be careful about that. I know it's a legal substance under Nevada law, but it is still a federally prohibited substance, and have no contact directly or indirectly with the alleged victim in this case. Is that Ross Canaglia Jr.?
Yeah, Ross Canelia. And
Okay.
I go file a TPO down at the courthouse.
I cannot give you legal advice. However, there are resources down at the courthouse to help you figure out if you need to do something like that. And you're welcome to come down to the
Man,
courthouse
these
and seek
filters
those
are
resources out.
amazing.
Okay, thank you.
Okay, that'll conclude this case.
Okay,
And,
thank
Your
you.
Honor, did you want to set that on the legal defender docket? And also, is there any testing?
No testing, none was requested by the city, and I think that makes sense given the nature of the offense. And yes, let's assign an LD in this case, please. Thank
What
you.
up, Miss K?
Thank you. That will be November 13th at 1 p.m. with Miss Wellborn.
Perfect. I'm looking for Travis Halvin, please.
Hey, thank you, Miss K. Appreciate that daily heart. And if you're new here, I would really appreciate if you hit that follow button. It's free 99. Don't be a Scrooge McDuck. Don't be a Mr. Krabby Patty.
Good
Hit
morning,
that
sir.
follow. It's free for you. It's free for me.
We are here in.
Hey, thank you for
looks
that.
like the number is cut off on my feed. Hold on one
Is that
second.
Sarah? Sarah, thank you. Appreciate that. Hey, JB 1983. Thank you for that heart.
Do I have
And,
this as
free 99.
25 CR 08824, Travis Antonio Hall? Looks like the underlying charge is use or possession of drug paraphernalia in violation of NRS 453566. coupled with an arrest for failure to pay or comply with court order post-conviction. At the beginning of these proceedings, did you have a chance to speak with Ms. Wellborn?
Yes.
Do you admit or deny that you failed to pay or comply with a court order?
The thing is, it wasn't like, they let me go from a certain place. You see what I'm saying? So, but I didn't know what day I was supposed to come to court or none of that.
Okay, let me speak with Ms. Wellborn for a few minutes, see if I can get a little bit of light illuminated on what's going on here. Ms.
Smiley
Wellborn?
and Jenna, thank you for that.
So our discussion this morning, Your Honor, was that he wants to resolve this matter today, and entertain an offer from the city as to how to proceed in his case. So it was my understanding, based on our conversation, that I think there just might be an understanding that he needs to admit to the failure to appear first, and then we can get to the plea on the underlying charge.
Kamala, thank you for the follow.
He was found guilty of the underlying charge, according to my notes. This appears to be a post-conviction failure to pay or comply.
Judge, let me give you some background here. He was a community court participant. He failed to appear for a case status hearing with Jenny Perez on 7/28, which was hence the reason for the failure to comply. He has an outstanding 8 hours of community service, which we
8
suspended.
hours?
I'm sure Your Honor has unfortunately heard about community court and us closing our doors. It looks like he may also have another PCS case pending in the RJC. I'm going to ask that you simply revoke that 8 hours of community service, convert that to time served, and close this matter.
I think that is, assuming that he admits, I think that is an appropriate resolution to this case. Ms. Wellborn, or do you think we're all on the same page on how this can
At
proceed?
this time, I was looking at the wrong thing.
Damn.
My apologies.
What's up with
No
these
worries.
people?
Okay.
people
Hey,
just-
Mr. Hall, here's
they
what's
just grab
going
any
on.
file.
You think he didn't show up
They
for
don't even know their
community
clients.
court. As you may or may not know, given
This is ridiculous.
forces larger than us,
is a
community
freaking
courts
kangaroo
doors
court,
are
if you will.
temporarily, God willing, temporarily closed. I'm looking for you to either admit or deny that you didn't show up for community court.
They're still stuck on Monday.
I showed up, but I left. We'll just say I didn't.
I got the
It don't
bag
matter.
over my head.
I'll take that as an admission. You came, but then you left before it was heard.
What up,
And
T?
I think that counts as an admission. Sir, I've heard from the city, they're recommending time served is the ultimate outcome of your entire case. Before I convert your sentence, the law affords you an opportunity to address the court. But since I'm inclined to give you time served, is there anything else you want to tell me, sir?
No, that's it.
All right. Time served is going to be the ultimate disposition of the underlying case. Thank you, everyone, for your hard work on this one. And best of luck to you, Mr. Hall.
All right.
Dennis Howard, please.
Dennis Howard.
Morning.
Good morning, sir. We are here in 25 TR 09774. Looks like driving on a canceled, suspended, or revoked license.
Damn.
At the beginning of these proceedings, did you have a chance to speak with Ms. Wellborn?
Yes, sir.
Yeah, have your rights explained to you, your options today, potential consequences explained to you?
Yes, sir.
All right, Ms. Wellborn.
Your Honor, my client intends to enter a
What up,
guilty
Patricia?
plea today. He has some other matters to address.
Okay. Then, Mr. Howard, to the charge of driving on a canceled, suspended, or revoked driver's license, how do you wish to plead today, sir?
No contest.
All right. You understand when you plead no contest, you don't necessarily admit the truth of all the allegations against you. Maybe there's a little bit more to the story than what shows up on the charging documents, but you concede that a factual basis exists that would support the charge if the matter went to trial. So you don't intend to fight the charge, and if I accept your plea, I'm going to enter judgment against you. You understand all that, sir?
Yes, sir.
And if you do that, you surrender your presumption of innocence, your right to a trial, your right to confront witnesses, and we'll proceed to sentencing in this
Hey,
case.
thank
Do
you
you
for that
understand that
heart.
as well?
Who sent that over?
Yes, sir.
All right. I find the plea is knowingly, voluntarily, and intelligently made, so I will
Ms.
accept
Kay,
a
thank you.
no contest plea in this matter. Ms. Gianoli, are we able to proceed to sentencing today?
What court is this?
We are
Kangaroo
judges.
court. This
Ms.
is what this
Wellborn
is
indicates
right here.
he's got more serious matters pending in both the second judge as well as the RJC for which he's being held. I'm going to ask you to impose just some jail time and close out this case, please.
How much time is the city looking for?
Normal fine on this is about $783. I'm asking for 5 days jail.
Ms. Wellborn?
And that would be time served, Your Honor, as he's been in custody, I believe, for a month.
Fair enough. Mr. Howard, the law affords you an opportunity to address the court prior to imposition of sentence. The city seeking 5 days of actual jail time. I understand you may have been in custody long enough for
Who
that
is
to
that?
be
Thank you for the
functionally
follow.
time served, but if there's anything further you think I ought to know at this time, now's your opportunity, sir.
No, sir. That's all.
All right, I'm going to sentence you to 5 days actual jail time. I will give you credit for time served on this arrest. So whatever that results to is what it will result to.
Can I
Best
get
of
some
luck to you on
credit
your
for
other
a
matters,
future
sir.
crime, Your Honor?
Thank you.
Since I'm already
That takes me
25
to
days
Norman
over.
Malos, please.
Bro's gonna
Your Honor,
straight to
he's at the
plug when he
docket.
gets out.
Okay,
Right,
I'll
Parker?
pick that up. Oh, I see. I see he's got an eval. Miss Massey, do I have a copy of that eval, please?
I'd be happy to send it to you.
Thank you very much. That takes us to.
Sounding competent.
Okay, well, I just want to take a look at it, but I'm sure we'll all be on the same page with what to do once we get it. That'll take us to Lynette Mullen, please. Good morning, Miss Mullen. How are you doing today?
Not
Not
just
so great.
ashamed. Just this, yeah.
Yeah, I understand, ma'am. It's,
other than
it's
being
a
in jail, I'm
process,
doing
and we'll
great.
get through it. And let's take it one step at a time. First off, ma'am, we are here in 25 CR 14622. Allegation is a violation of 484C.110 DUI, alcohol and/or prohibited substance above the limit, charged as a second offense. At the beginning of these proceedings, did you have an opportunity to speak with Ms. Wellborn?
Yes, I did.
Okay, Ms. Wellborn, is your client intent to plead not guilty today?
That's correct, Your Honor.
Okay, Miss Mullen, for the record, then, to the charge of DUI, how do you plead today?
Not guilty.
Okay, I'll take a not guilty plea on the DUI charge. Let's discuss conditions of release. Let me hear from the city, please.
Thank you, Your Honor. Here, law enforcement responded to a reported unconscious female in the driver's seat blocking lanes of traffic. When law enforcement responded, they made contact with the defendant, sole occupant, asleep in the driver's side. It took some effort, but they were able to wake her. She had the standard observations indicative of alcohol consumption. She was unsteady on her feet and had to be assisted out of the vehicle. She refused field sobriety test, PBT, as well as an evidentiary. Unfortunately, a draw was unable to be conducted. She has a 2021 DUI conviction out of RMC. Of concern to the city, her risk is a moderate given her history. Her BAC at intake was a 273, which is quite extreme in light of the fact that this is a second offense. This defendant poses a grave risk to the community, Judge. I'm going to ask that you impose $5,000 bondable in this case. Should she be released, conditions that she obey all laws, consume no alcohol or drugs, and upon her release, she be either forced to install a SCRAM device or an OSM device, please.
All right, Ms. Wellborn, please.
Your Honor, there are less restrictive means to ensure my client's appearance in court and to protect the safety of the community. Ms. Mullen has been sober for quite a while. She's fallen off. She's had a relapse.
Hey, what up, HD?
But she has maintained that sobriety since her first DUI in 2021.
Jordan?
And wants to get back on track.
Reno.
She has a lot that she has to get back to in the community. She's got her job at Tamarack Steakhouse, where she's worked for the past 15 years. She has 2 young adult children who live with her and rely on her financially and for transportation purposes that she needs to get home to. She also helps with the care of her mother. She's active in the community. She plays sports in our community. So, but for the fact that she has an alcohol problem, she is an upstanding citizen. She's willing to do testing and comply with the conditions of the court in order to ensure her appearance. But it's really the sobriety and making sure that we keep her on track with sobriety that will protect the interests of our community and community safety. But she does understand that given the nature of this, it is a DUI second, that the court may want to impose some amount of monetary bail. The most that she could pay monetarily would be $250, Your Honor. Or $1,000 bondable, excuse me.
It makes it funnier.
Ms. Gianoli, does she have any other criminal history beyond the 2 DUIs?
Your Honor, we didn't run her criminal history, so candidly, I can't tell you that information.
Okay.
You didn't run her criminal history.
I do find that the city has met its burden to prove by clear and convincing evidence that given the community safety concerns and frankly, given that this is a second DUI conviction, the ability to be a law-abiding person and comply with court directives is met. I am going to order the conditions first, and then I am going to consider what I think is the appropriate amount. First, I'm going to order bail, I will make it bondable. I will order that if you are able to secure bail, you will report upon release for enhanced supervision, subject to electronic monitoring, either an OSM or a SCRAM. It will be up to your Ms. Mullen's choice which option she elects. I will order that she obey all laws and strictly consume no drugs or alcohol, including the use of marijuana. A second offense DUI is a very serious offense. DUIs are among the most dangerous, although not necessarily the most morally culpable cases that we deal with, just given the grave risk of death in the community. A second DUI is especially troubling to me, frankly.
Zed, thank you for the follow.
I can't get down to $2,000 bondable. $2,500 bondable is going to be the amount. I understand that that's more than she thinks she is able to come up with. She's going to need to work her resources. She has extensive ties in the community. She's going to need to work those extensive ties in the community to figure out a way to find that $2,500 bond. That's
Yes,
the
Emily,
lowest amount that I am comfortable ordering in this case. And Ms. Mullen, I need you to understand that I think I am giving you a significant break by going down to $2,500. I do wish you the best of luck. As I say, although these are the most dangerous charges we deal with, I certainly understand that if you are suffering from a substance abuse disorder, that can be a very difficult mountain to climb. And I sincerely hope that you embrace recovery and sobriety, and I wish you all the best in that journey. But for the time being, I got to protect the community. $2,500 bondable, obey all laws, no drugs, no alcohol. If she secures released, enhanced supervision by OSM or SCRAM, that's going to be court's order. Thank you.
Hey, I think if I was in front of that court,
absolutely
so.
Book
Yes,
at
me.
Thank you.
Thank you.
I would not. I definitely not get a slap on the wrist. They'll be bringing up priors from over 25 years ago. They would have run my.
That will take us to Brittany Roberts, please.
Neta. Yeah, right. They would have probably been trying to send me up to prison.
Good morning, Ms. Roberts.
Habitual
We
criminal.
are here in 25 CR 14659. Allegation against you is petty larceny in violation of Reno Municipal Code 8.10.040.
Are these live now?
At the beginning of these proceedings, did you have an opportunity to speak to Ms. Wellborn?
Yes, I did.
Then let me turn my attentions to Ms. Wellborn. What are we doing here today?
Nah, I like
She's
to
going
be
to enter a
just
not
a
guilty
clown.
plea today, Your Honor.
Okay, Ms. Roberts, how do you plead to the charge of petty larceny?
Not guilty.
Okay, I'll take a not guilty plea.
Hey,
Let's
Russell,
discuss
thanks for the
conditions
share.
of release. Let me hear from the city.
Your Honor, in this case, I did not see a pretrial assessment.
She just got her
I'm
second
looking
conviction.
Yeah, I still don't see one, Judge. Here it appears that she entered Macy's where she took approximately $148 worth of merchandise. Fortunately, that was recovered. Although I don't have her criminal history, Judge, I did look at her history as it pertains to RMC and Odyssey. She had a 2021 and 2024 petty larceny. Both of those occurred at Winco, but this appears to be perhaps an ongoing issue for her. I do have concerns given that, Judge. I am asking for a nominal bail, though. I'm asking for $250 bondable.
Nominal?
Should she be released, conditions that she obey all laws, consume no alcohol or drugs, and stay away from the Macy's
Might as well
store.
hand her the $25 to allow her to get out.
Your Honor, the 250 is out of reach for my client. She is asking for
Out of her
a release with conditions, check-in conditions, whatever conditions the court would find appropriate to impose. She's lived in the community for over 20 years. She is getting back to work. She's working through a temp agency and she's working on her CNA license.
Okay.
Go sell
She does not have the ability to post any amount of money bail at this time and wants to get back to her classes. She has a bed waiting for her at our place where she's been staying.
She has a bed in
as far
jail.
as the nature of the offense, we understand there may be a pattern there that she needs to look at, but the property was recovered. She never even left the store. So I think that, as we work through the
She had that
negotiations
intent.
on this, there is opportunity for her to,
What up, Matthew?
pay her restitution and move forward in this case. She has no failures to appear in her background, so nothing to suggest that she wouldn't make her court
Who's
appearances.
she waving at?
May I say
She wants to
something,
speak?
Your Honor.
Ma'am, hold on. Just to remind you, you have the right to remain silent, and anything you say in these proceedings can and very likely will be used against you.
Absolutely.
Ms.
Your Honor.
Wellborn has spoken very well on your behalf. It
Let her
is
speak,
generally
Your Honor.
unwise to speak on your own
wise, Your
behalf.
Honor.
If you have a question and you want me to allow you to speak to Ms. Wellborn for a few moments, I'm very happy to have Ms. Massey put me in a breakout room so you can speak to your attorney.
We want to hear.
But it's probably not the best idea to speak to me directly, although I will allow you to.
Yeah,
It's just
let
not
her
necessarily
speak,
a good
Your Honor.
choice.
We want to hear her.
I'd like to speak anyway.
Okay.
All right, good.
Go ahead. What would you like me to know?
The two other petty larceny charges that were brought up by the city One was, I pled not guilty and ended up not being guilty. I was not convicted of it.
Okay.
And the other one, I have had my records sealed in the past, so that shouldn't have
sealed?
even been brought up.
Oh, it shouldn't have been brought up. Oh,
All right.
You're gonna
Well,
tell
I
the-
will
tell us how
actually
the
compliment you on
justice
you
system's
acquitting
gonna
yourself
work here.
quite well in addressing the court, although I will admonish you that it is almost always a terrible idea. Look, here's my cut at this. It's a petty larceny charge. I do worry about potential recidivism. It's a nonviolent offense. The risk to the community is losing some merchandise here and there, which is not nothing. But on the
I pay for
balance, I
it.
find that an own recognizance release with conditions is likely sufficient to secure her return to court throughout these proceedings and to keep the community safe. To wit, I'm going to allow you to be on your own recognizance subject to the following 3 conditions. First, you will obey all laws. If you pick up another petty larceny charge, it will be a violation of my order of release. And if you see me again on an allegation that you violated my order of release, I will simply have you remanded until time of trial. Do you understand that? Number 2, you're going to consume no drugs or alcohol. I want you in your right mind throughout these proceedings. I'm not going to order that you test, but I want you sober and thinking clearly. Miss Gianoli, Miss Wellborn, which Macy's was this? The one at Meadowwood Mall?
I believe so, yes, Judge.
Okay.
Macy's
Miss
is
Wellborn,
still in
do you concur
business?
that that's the location?
Yes.
Okay. I am going to order that you stay away not only from Macy's, but from the entirety of Meadowwood Mall.
Hey, what up, Kimberly?
I want to reduce the risk of a further alleged petty larceny at any of those locations. And so my stay away order will be from the entirety of Meadowwood Mall. I think that adding that additional buffer zone helps
From any
offset the
store,
lack of
Dollar Tree,
monetary
Target, Walmart.
bail. And so I'm comfortable with that exchange. Anything further from
Only
the
allowed
city
to
on this
shop on
matter?
Amazon,
No, Your Honor,
online
thank you.
shopping
Anything further,
only.
Miss Wellborn?
No, thank you, Your Honor.
Okay, that's going to be the conclusion of this hearing. Let's get an LD appointed for the matter and get a trial date set.
Thank you, Your Honor. That would be November 13th with Mr. Puentes.
Perfect. Thank you so much. I think I might be looking for Shane Robertson.
Shane, come on down to The Price is Wrong.
And we can go back
So
to,
she will just visit another shopping mall and it was how many
morning.
malls? Anybody
Good
from
morning,
Reno?
sir.
How many
How you feeling
malls
today?
is there in Reno?
Good.
Doing okay? All right. We are here in 25 CR 02564, as well as 25 CR 09615. I understand that there are potential revocations in play. I understand that we're here on arrest for failure to pay or comply with court order. I've reviewed a little bit of this file, and so I understand that you previously had some warrants issued and also some motions in front of the court. At the beginning of these proceedings, did you have a chance
Let
to fully
everybody go.
discuss
The
these
Price is
matters with
Right
Miss
at this
Wellborn?
Yes.
Okay. Miss Wellborn, here's kind of what I'm looking at, and then I want to talk to you. We've got some warrants out. There was a motion to dismiss based on a recital that he perhaps resided in Michigan. And yet he's been arrested here in Reno. And I don't see that he's completed or complied with any of the conditions, although because this is videos and we're all doing this by Zoom, I might not have comprehensive eyes on everything that's going on.
Reno is
Before
wild.
I ask him to admit or deny anything we should talk about.
I'm sorry.
About where he's residing?
Anything that you think is germane to this discussion.
I like the vocabulary of this.
So
of this,
I think
judge here.
my
He's
understanding
dropping
is that
$5 and
he
$10
is
words.
still living in Michigan and is here presently visiting relatives.
Okay.
And that's where this occurred. And I mean, if we're going to discuss revocation, we do have a justification and an argument for reinstatement to those terms because of, due to a lack of understanding about being able to complete those conditions in Michigan. And then also as far as the rehabilitation that was ordered, he is currently still doing his outpatient treatment. But that had not been reported to the court because it wasn't complete. So that's where we're at now, that his time here is temporary.
Okay. There's a couple ways that I can proceed structurally.
Proceed with
The
caution.
first, and as Ms. Gianoli knows, I don't mind resolving cases,
What up,
even
Cajun?
serious ones, even ones with revocation. However, I am mindful that as a pro tem, what I might do may differ from what Judge O'Neill would do. So I could continue this matter out to Monday so that he can address this with Judge O'Neill. If I were to do that, I would be inclined to impose a no bail hold and have the matter trailed until Monday so it can be resolved there. I am comfortable hearing the matter as well. So with that kind of lay of the land, Ms. Wellborn, do you want a chance to talk to your client?
Yeah, if I could have a moment to speak.
Absolutely so. Let me get punched out into a waiting room and then we'll see what's what.
Placing you both in the waiting room, Your Honor.
Thank you so much.
You're welcome.
Hey, so did you understand what the judge just sort of explained right now? That it might be within your interest to wait until a Monday hearing to have all of the facts before us. I'm of the opinion that at this point it doesn't really matter, because we have to make an argument for your reinstatement anyway. But then that subjects you to potentially
Are you in the bathroom, bro?
having to do, being revoked and having to do some jail time, right? But I mean, you're going to be subject to that no matter what, right? Like, because you're here for a revocation hearing. It's within the judges. I can make the best argument I can to reinstate you, to allow you time to bring your proof of treatment, to go and get your OSM device, or to figure out what you have to do in order to comply with these enhanced conditions in Michigan.
Apparently
and what
they
those
are,
agreements
Kelsey.
are. And we can make that argument, but just understanding that whether we do it today, whether you do it on Monday, you're facing the same potential
But you got to remember, there's people in there too. So there's other people that can listen to their conversation. There's like 3-4 people on the right hand side.
That's what I came out here for, to see Judge O'Neill because I had an motion.
If you will.
I have my.
I understand. Okay.
Proof of
Well
completion.
then, okay.
See if that makes
Okay.
any
You're right.
sense.
You're right. I'm sorry. You should definitely wait until Monday then and get your motion heard in front of Judge O'Neill. So are you okay with sitting until you have the opportunity to do that and
I'm no
address
lawyer,
everything
so
on Monday?
I can't say.
Does it matter if I do it today or Monday?
It will if your motion is before Ms. O'Neill.
So
And
the
I
best-
would say that you should address it with her.
Okay.
Sounds like
Okay, I think that's probably the best. I'm sorry.
What do you guys think?
He
For
had
you
discussed
legal,
that and
for
I
you
forgot
internet
about that
lawyer,
detail.
you
So
Google
I'm
lawyers,
going to suggest
is
that
she
we
violating
hang
her
tight. Worst case scenario, you're
lawyer-client
accumulating time
privileges?
if you get revoked.
Streaming
But
his break
I think
room
that
is
that's
wild.
your best course of action.
Well, then again, she
Yeah,
does have
about
she
the
does have
warrant.
a
She
clown
said I don't have to pay anything until I'm
wig
done with the
going on over
program.
there.
So I don't know why she issued me a warrant. That's what I'm confused about.
Ms. O'Neill?
Yeah. I don't know who did, but like I told her I was going to rehab. I had a motion before I went in.
It's because the proof hasn't been submitted to the court. You have not reported to the court that how and whether you have complied with the orders of the court. It's up to you to keep the court updated with whether or not you're following through with all of your conditions.
But then
And so if they don't
thank you for that
have those things reported to them within the certain allotted period of time, and I think like explaining that, like if sitting right here that
thank
you
you.
can show proof of rehab,
Kelsey.
I think you're going to have a hard
you.
time with the well, I didn't think that I had to do that since I went back to Michigan because it was ordered for Nevada. You're going to have a tough time, right? Because, you still you still have to do like victim impact.
I think the court streamed the wrong
Michigan,
room.
or there's ways to do them in Nevada to sign up and register for those classes to show that you're getting those things done. And so that's what we're looking at.
This is private. It is a private room.
Okay.
The judge is not in here to hear.
So I mean, I'm inclined to
the
say
prosecutor's not here either.
I mean, it's really up to you. I mean, I think Judge Silva can hear these things out. I don't have your motion. So I don't even know that I can comfortably argue your motion for you right now. I need to get my hands on that and let the legal defender for Monday know that that motion's been filed. So I do think, you know, as far as getting the full scope of legal counsel,
Tag, you're in.
waiting until Monday is the right thing to do.
We're watching a private conversation between
Why are
an
we getting like
attorney
a
and her
bail
client.
amount on Monday too?
You won't have the bail amount because you're here on the warrant.
So I
You know,
won't
but maybe we can ask for it to be quashed
Now she's
today. You know, maybe that's what we can ask for, so that way you can get to court on Monday. And you know, and go from there.
Okay.
Okay, maybe we can start there.
Yeah.
Okay. All right, let's see what we can
Hey,
do.
Emily,
All
thank
right,
you
we're
for the
ready, you
follow.
guys.
Charissa, thank you for the Go Popular. Highly appreciate you guys. What do you guys think? Hey, what up, Mondo?
All right,
Oh,
we
I
are
got it.
back
Tag,
on
I'm in.
record with Mr. Robertson in 25 CR 02564 and 09615. Miss Wellborn.
Your Honor, we are hoping that the court will entertain addressing specifically the failure to pay and quashing the warrant, so that he can address this in person with Ms. O'Neill. Excuse me, with
Judge O'Neill, of
Judge
course.
O'Neill.
No worries, no worries.
On Monday.
Okay, let's talk
Roddy,
about that.
Nana, thank you.
Let's
talk about that hair, Your Honor. Where do you get it done at?
Judge,
That's
may
what
I
I
offer
wanna
a
know.
suggestion?
yes, I am all ears because I think I'm all ears, please.
So Judge, I suspect what Judge O'Neill wants to do here, as we oftentimes do, is to keep this suspended sentence, not reinstate, not revoke, not
Madagascar
address it at this
Saloon.
point, but leave it to the discretion of the trial court. I agree with Ms. Wellborn that we should address the issue of the failure to comply with his failure to report upon his release and address custody
He's all
status.
no
And then
ears.
we can go from there as far as setting a trial date if it is still his intention to maintain a not guilty plea today.
Okay, so let's pick it up in 25 CR 19615. Mr. Robertson, you were ordered to report upon release in this matter, and we think that you failed to comply with that order. Do you admit or deny that you failed to report upon release?
I deny it. I went there. It was just a big misunderstanding.
Misunderstanding, you say?
I thought I didn't need it because I don't live in Nevada. So
Well, let's give it a second and we'll.
Because I don't live in Nevada.
That's okay. I'm gonna log it as a denial, Ms. Wellborn. Okay. So I'll take that denial. Can we get this set for Monday in person, Ms. Massey?
Judge, he's current on the assault case. He's currently already set for trial on October 16th.
On October 16th. Okay.
Yes.
If depending on what we do on the other matters, should we just move everything over to the 16th so it can all be heard at once?
Yes, we can put the revocation case on for the 16th as well.
Okay. Ms. Wellborn, does your client intend to deny the failure to pay or comply with post-conviction matters in the DUI case as well?
DUI?
I think deny because he has explanations.
Okay.
He has an explanation.
Mr. Robertson, then for the record, to the charge of arrest or failure to pay or comply with court order in 25 CR 02564, are you denying that as well, sir?
I'm sorry, I can't hear you.
Oh, not a problem. Are you denying it, that you failed to pay or comply with court order in the DUI case as well?
Yeah.
Okay, I'll take that denial as
Thank
well.
you for that, Daily
I'm
Heart.
going to have all matters continued and heard on October 16th, the trial date, and then I will hear custodial status. Ms. Gianoli, let me hear from you first, please.
Thank you, Your Honor. Here, with regard to the warrant, the court imposed a $2,500 cash. I'm sorry,
That's what it
I'm
sounds
asking for
like.
$2,500 cash warrant. Here's why, and here's what's
Brian,
changed.
thank you for that.
I have concerns. I know the defendant denied
Nevada.
the allegations that he failed to report. There's a reason that Judge O'Neill ordered that. In this case, it's alleged that he was extremely intoxicated at the airport. In light of the fact that he has 179 days suspended for a DUI second, hence the reason for the requirement of that OSM, which can be monitored whether he lives in Nevada or not. In the meantime, he has now moved to Michigan. He's indicated he was here in court services for 1 day to visit people that he knows here. He is unemployed. He made a request for a Zoom hearing. I have grave concerns, Judge, that if we let him go, he's not coming back and does not have the financial ability to come back.
Yep.
His risk is at a 10, which is an elevated risk,
What do you
Judge.
guys think his risk factor is?
I'm concerned given the allegations of violence, given the ongoing allegations of alcohol use,
Your
and given the
volume's a
fact that
little
he
bit
no
low.
longer resides in this community, in this state, that we're not going to see him again. I'm asking for $2,500 cash. Conditions should he be released that he obey all laws, consume no alcohol or drugs, and upon his release that he install an OSM device.
Ms. Wellborn.
Your Honor, I do not think that my client is a risk of flight. I understand the argument that's been made, but I want to point a few things out.
Ms.
He
H,
filed,
thank you for that.
you know, the moment that he found out that he had a warrant issued and there was a lack of compliance, he filed the motion. He got to Nevada to try to address these issues. He's sitting there in jail right now, attempting to address these issues, and then he was picked up on the warrant and arrested. So he is here to resolve this, to get on track, to try to clear up where he may have misunderstood how to register and sign up for these conditions, how it played into the fact that he does live out of state.
Laurie,
Looking
thank
at
you for the
that
follow.
order, it does not appear that there were conditions laid out on how he can achieve compliance with these things in Michigan. Some of these orders say, you know, so we have an agreement and understanding with California on some of these things, but what are the conditions for Michigan? You know, I
Then he
can't
can't leave the state
look
of
into,
Nevada.
you know, the past and
Very
see how he
simple.
was advised on those things. But certainly giving him that opportunity to figure this out. And then some conditions were met, which we'll discuss when this is heard on the 16th, but some of those conditions were
Right,
met.
Tonya, I
he did go to
noticed that. I
rehab.
was
He
gonna
can
say
show
something about
proof
that,
of the
him crossing
fact
his
that he
arms.
did do his outpatient treatment and he's continuing in treatment
She
through a
looks better
center
with
in
the hat
Michigan. He just didn't report that. So I think that, you know, showing the fact that he did come to the state to resolve these issues shows that, you know, he's here to take care of this and get back on track and comply with the orders of the court.
Okay.
You know, I'm not sure if you'd be interested, but I do have some information on martial notes for both counsel and Your Honor. And also there was a motion that was filed previously in September requesting a delay on the OSM due to financial hardship. Judge found ordered that motion was denied due to the violations of his conditions of his release, making him a danger to the community. If you'd like to know about those marshal notes, Your Honor, he has not checked in with the Marshal Division since the last time we saw him was on August 21st, at which he had appeared via Zoom. Judge ordered him 30 days to provide proof of enrollment in a rehab center and proof of self-help meetings. He was ordered to attend those self-help meetings daily until he was in the program. He has failed to provide documentation to the court and has not had communication with his marshal.
I never thought about that. That's crazy. That's wild.
Ms. Wellborn, would you like an opportunity to speak to your client for a few minutes before we proceed?
Yes.
Thank you. Go ahead and dump me out again. Let me give you the lay of the land. Ms. Giannoli, are you still there?
I am, Judge. Yes.
Let me give you the lay of the land before you talk to your client so that you know what I'm thinking, and I will aver to you that I have not made up my mind. This is just where I'm at based on everything that I've heard right now. I've heard it said that he was here visiting friends for a day. I've heard it said that he got here attempting to address these issues, but he had a Zoom hearing set for the first, and I don't understand why that, his Zoom set for today was based on, or for yesterday, was based on him being in Michigan. So his presence in Nevada and his absence from Nevada to me are unexplained and candidly troubling. Given the nature of the offenses, I do have severe concerns about community and public safety. I'm also concerned about his ability to follow court orders. I am inclined to set a bail amount $2,500 seems reasonable to me.
This
I
fool
would
wanted to do it in
hear
person.
Argument on amount. I
He's
would
getting
hear
what he
further
wants.
argument
Keep
if you
his
think
ass.
maybe the city hasn't met its burden by clear and convincing evidence. As I said, I've not made up my mind. I'd hear argument on amount. I'd hear argument on whether maybe a higher amount but bondable would be sufficient. The conditions laid out all seem sensible to me. Obey all laws. He's got to do it anyways. No drugs or alcohol. He's got to be doing that anyways. Report upon release because that's what he was supposed to do. Absolutely so. And then probably enhanced supervision, albeit for the next, 2 weeks by Scram or OSM, which is something he was supposed to be doing anyways. So that's the lay of the land where I'm at right now. But I do hear you.
Let him have it, Your Honor.
On
Give it
maybe
to him.
some mitigating factors, some things that he has done that we simply don't have record of. And I don't know if you have any of that information at your fingertips. I don't know if you have any of the registration for rehab. I don't know if there's anything that you can show me today that might be helpful in balancing the scales. But
Like straight up,
that's
he
the
blew
lay
it.
of the land
He
of where
messed
I'm
up.
at. And given all of the information, I do
They're
think
getting
that it
breaks
is
at this
best if you
kangaroo
speak to your
court.
client for a few more minutes, and then we'll come back together and figure out how we move forward.
Okay.
You're
thank
done,
you.
son. You're done, son.
Your Honor, placing you in the waiting room.
Damn, son. Ay. All right, so we're in the breakout room
So
again.
it's not looking really promising. And I think some of that is also because you haven't really explained the whole picture here.
Book him, Dano.
So just so you understand where we're at is all,
Don't drop the soap.
anything about revocation, all of those things have been set for the 16th of October. And now we're talking about, do you have to wait there in the Washoe County Jail until the 16th of
Hell
October?
yeah.
So, the conditions that the court will look at are whether or not you present a risk of flight. And I think the court kind of laid that out. So I need to be able to make a better argument for why,
possess a
what we
risk
can
of
say
flight.
to the court that's going to guarantee that you're going to show up to court on the 16th. A better explanation for why
It
you're
behooves
even in
me,
Nevada when
if
you
you will.
had a video appearance set for yesterday.
Hey, thank you,
which
Chad.
also I'm confused about because I thought that was denied.
Yeah, that's what I was thinking. I didn't get no response
So-
back. Flew out here. I wasn't seeing nobody. I have no relatives out here, so I was coming
I see. Okay.
strictly for the motion. So
Strictly for the motion.
for the
Okay.
motion in the
I have my
ocean,
proof of everything I
homeboy.
need to show them with me, but
That was it. I came
Okay.
here for the
I
motion.
have
Okay,
everything
so
to show
you
them.
have that proof with you. Is it
Yeah.
with you at the jail or
No,
where
it's,
you're
You
staying?
better
I
settle
forgot out
in,
my friend's house
homeboy.
that I'm staying with right now, but she can bring it over. No,
Okay.
I have it. I have it all in a folder.
Forget about it,
Okay,
homie.
that shows, that you've been in rehab, that you've been doing.
At the completion, and everything signed by my therapist and everything. I got the phone
Okay.
numbers, everything.
Okay. So,
He's putting the whole courtroom to sleep over there.
All
Hey, what
right,
up? I'm
and
not
then-
the one. Hey, Rye, thank you for the follow. And if you haven't done so, please do so. Hit that follow button. It's free. It's free for you, free
Miss
for me. Don't
Wellborn,
be
I'm
a
gonna
Mr.
send you
Krabby
a
Patty. Don't be
Go
a
ahead.
Scrooge
I'm going to
McDuck.
send you a chat.
Hit that
Okay.
follow. Hit that follow. It's free, my favorite.
And yeah,
Price. Hey,
I'm
what's up, Smoggy
struggling
Ladder?
financially, so my phone's been off, so I haven't been able to get
Yeah,
any calls
see
or
all
anything.
of those things in making a determination about your
Ted, thank you
custody
for the follow.
status don't actually help you, right?
Nope.
Like they
What up,
add a
Dan?
point, like saying I don't have a phone, I don't have a place to live, I don't live in the community. All of those things weigh into it works against you, right?
Yeah.
Because what they're looking for is
Drop your
stability
daily
in the
heart. Thank you,
community, that
Nana.
you're not going somewhere anytime soon. All of those things. So how are I need
Yeah.
I think our best argument right now they've already made, and he doesn't seem very convinced by it, is that the sole
Hey,
purpose
look.
of you being here is to handle this court matter.
That's BS.
Yes.
To get
Okay.
a phone, to get service
And
on the
I've
phone,
already made that argument. So I
$10
think
a
you
month,
just have to
unlimited,
balance those
with total wireless.
expectations that they might be
Unlimited calling
imposing
and
bail on
unlimited
you today, and you
texting.
might be sitting there until the 16th.
So who can't afford $10?
Until you're called to court.
I could probably go to my cash right now and find $10 of coins, or in my ashtray in my
Just
car.
like if I don't get out, because I have
You're not gonna get out.
meeting today with the IOP, so I can get kicked out of that. Yeah.
Okay.
And I'm
And
in
they also,
school.
yeah,
I'm
Miss
not
Leanne,
trying
they
to
got
get
free
kicked out.
phones.
I'm like only have like
Phones are
4
free
classes till I
99.
graduate.
Yeah.
So I'm like busy. I'm not like just out.
Busy?
Out. I'm out.
Okay.
home
Busy drinking?
24/7.
Okay.
Don't have a
I
car.
mean, I think we'll push that argument home.
Okay.
I'm not seeing a chat.
What is this guy running a multi-million-dollar company? I don't see it.
That's okay. I was going to send you something, but
Yeah,
I'm
what a
not
phony.
finding it real quick.
What up, Chantel? Do you have reverse phone calls in the U.S.?
So was the Zoom appearance, just as a question for our court staff, was the Zoom appearance approved or denied?
Now he's in school.
I didn't get anything.
I'm asking the court.
I'm sorry.
Stand by just one moment. Let me look at his 2564 case.
So in the U.S., it's different. Phone. So I know outside the United States, when you make a phone call to somebody, the person receiving the call or receive the call for free. In the U.S., you gotta have active service on both of the lines in order for you to receive and make service. So it's a little bit different out here. What did he do, man? What did he do?
Okay.
DUI.
Yeah.
Then got arrested at the airport for being belligerent drunk on the day he was supposed to go to court via Zoom. And he was supposed to be in Michigan, but he was in Reno. Hey, where do I start over here? Let me see. Oh, wow, he looks young. Wow, what up, Manolo?
I'm not finding the order on that.
I mean, in my understanding too is I don't even know that usually, can't we just get it approved via email?
It would have been sent to him via email. I'm looking right now for that response from the judge.
But the motion was filed.
The motion was filed for an appearance via Zoom. And
Okay, thank you.
That anything was sent advising him whether or not he could appear via Zoom. However, he was arrested on the date of that motion hearing. So it's
okay. I still think that's our best argument here. So let's try to talk to him again.
Be careful, Dylan.
Can you post any amount of money bail?
Yes, I can.
How much?
Depending on what it is.
$25.
Okay, so like if they did $5,000 respondable, it's like 10 to 15% of that has to be posted for bond plus
Hey, Kayla,
collateral.
thank you for the follow.
How much is that?
10%, homie. Come on.
Like $500.
Yeah.
Okay. Okay. Sounds good. I think we're ready to proceed. Thank you.
Appellate hearings public. I'm not sure. I couldn't tell you, Yenny. I wish I knew.
I really appreciate you looking that up. That was very nice of you.
No problem.
Oh, he has money. All right. We got the Your Honor.
All right. We are back on record in 25 CR 02564 and 25 CR 09615. Ms. Wellborn.
Yeah, and Your Honor, I do want to apologize to the court. I think, some of the confusion here is not quite thinking we're going into a revocation when really we're doing a custody status hearing.
I understand.
So I really appreciate the extra time, and I apologize to the other people who are waiting. So we've had a discussion. So I want to continue on this.
I've never been able to see discussions.
We cleared up some things. My client is here to address this issue. A motion for a remote appearance was filed. We had the court staff take a look to see the result of that motion, and there was no response sent to him. So he came to the community to go to court yesterday and then was taken into custody. So I do think that the goals here, and he came to the state with all of that proof of rehab, his explanation. He has an appointment today, correct, with IOP?
Yeah.
That was today that he will miss. So the whole point of him being here is the discovery that he had the warrant issued and came to Nevada for this court hearing and has these appointments that he can prove he has to resolve this issue.
Okay.
But understanding where the court is coming from, we know the argument for, he lives in Michigan. This is the only thing keeping him. He gets that, he understands that, but he also is enrolled in finishing up his diploma, but those are things that can wait until these issues are resolved that could compel him to court on the 16th.
Okay.
But understanding where we're at in the grand scheme of things, a more reasonable bail, given the fact that he is unemployed, you have to rely on other people, would be $5,000 bondable.
Does she really have that hat on?
Is what we would request.
Okay. All right. I've certainly had more colloquy than
What up,
usual with
Boston?
Ms. Wellborn, so I'd be remiss if I didn't give Ms. Gianoli an opportunity to say anything further before I make my
thank you, Chad.
ruling, Ms. Gianoli.
The case
Your
has
Honor,
a
I'm
lot
going to
of
rely
moving
upon
parts.
my prior arguments. I think his actions have shown a likelihood to not
Big
comport with
She's,
court
thank you for
process.
the-
He was
for the
supposed to
fo- for the
provide
share.
proof to the marshals and maintain
Is this
contact, which he hasn't
live?
done since August. I know he lives out of the area, but there's nothing that prevents him from picking up the phone, utilizing email, and maintaining contact. I continue to express the same ongoing concerns of a potential flight risk. Given his lack of financial stability, I worry that he's not
If he's
returning,
smart, he
Judge.
shouldn't
I'm
talk.
going to remain with my prior arguments.
Okay.
Hey,
Thank you.
Superface,
And then Ms. Wellborn,
Superface,
I'll
Superfan,
hear a final
or
word from you since that's the
Superface.
ordinary sequence. Anything further to add to the discussion?
I did see the arguments
Well,
have
look at
been
him. He
made
has his
that,
arms
you know,
crossed
the goal here
Certainly.
is
the whole
all
time.
the issues.
What up, Cynthia?
Just
Welcome
wanted to
back.
make sure I provided you an opportunity. Both
Thank you.
both counsel in this case
I
have
like Reno. Do you guys like Reno
expressed
Court?
their
It's a
arguments
kangaroo court, but I like
quite
it.
well. I understand the perspectives for both. I have to say I find this to be a troubling set of facts. Ms. Massey, I do have a fact question from you. It has been relayed to this court that no response to his motion was forwarded to him. Do the court records indicate whether we responded to his motion for a remote appearance? I see that one was set, but was that emailed to him?
I like Reno
Your
911.
Honor, I was looking for that. I do not see that the order was entered, and so therefore, no, it was not sent. The
Okay.
one that was sent to him was his request to modify pretrial
What I want to know,
conditions,
what
the
kind
one
of
that was
public
order
defender wears
denying
a
the motion to
freaking filter to
modify
court?
relative to the
That's an outrage. That's a
OSM.
slap in the
That
court of
was
the
sent
face
to
right
him,
there.
and he acknowledged that on 9/25.
He uncrossed his arms.
Understood.
About time.
I am going to
What up, no Bob?
impose $5,000. I will make it bondable.
cold.
In the balance, the city has clearly met its burden by clear and convincing evidence to show that cash bail is warranted. I find that a higher net amount, but bondable, is sufficient to cover the span of 14 days. If he flees, then 5,000 is going to be forfeit, and you'll be in bondsman land. So don't do that. I expect to see you here in court on the 14th. If you're able to secure the bond in the amount of $5,000 for the $5,000 bail, obey all laws, no drugs or alcohol, immediately report upon release to enhanced supervision monitored. I'm going to say scram only on this one. I want it to be something that is continuously on his person for purposes of ensuring that there can be no question mark about what he is supposed to do. He is supposed to wear the scram device. Anything further from the city on this matter?
No, Your Honor, thank you.
Ms. Wellborn, anything further?
Just to clarify, court date is the 16th, not the
October
14th,
16th for all purposes, correct?
Thank you.
And
Judge, and is that 5,000 on which case?
I am going to set it for the assault case for which the trial is pending.
And then did you want to set bail on the revocation, on the suspended sentence case?
I'd be inclined to just OR it. One bail is sufficient. If he posts, he posts.
Okay, thank you.
If somebody has contrary thoughts, I'm certainly happy to entertain it. But functionally, I want it to be 5,000. I'm okay with it being bondable. I share the city's grave concerns, frankly, but I think that this is an amount sufficient to secure justice in this case.
I'll defer to Your
Hi from
Honor,
England.
Judge.
What's up, user?
Okay, that's how I'm gonna do it then. OR on the post-conviction matter and 5,000 bondable on the assault case for which the bench trial is set.
Hey, what's up, guys? Let's get up to 50,000 taps on
Your
the
Honor,
on the
can you ask him to report
on this stream here. We
immediately
got
upon
42,000.
release?
I made that a condition of the
taps are
bail
free.
order, but I
Stop
will
being a
reiterate
Scrooge
that as
McDuck.
soon as
Stop being
Mr.
stingy.
Robertson secures release, he must immediately,
On the other
no
stream,
other
we got
stops. He's
17.
not
Let's get up
stopping
to
by
20
Taco Bell
on
or
the other stream.
McDonald's. He is coming to court to report upon release.
And if you're watching on YT, hit
Thank
that
you.
thumbs up, por favor, y gracias a ti.
I think that takes us to Anahi Salerno.
Oh, they changed her hat. She's already gone. He's already gone. What'd he do? The judge is funny.
Hello.
Good morning, ma'am. How are you feeling today?
Pretty good.
You're doing
RJ,
okay.
thank you
All
for the
right,
follow.
good. We are here in 25 CR
Elber, thank you for the follow.
14650. Single count of domestic battery is alleged against you.
Did she
At the
say
beginning of these
domestic?
proceedings, did you have a chance to speak with Ms. Wellborn about your case, your rights, your options, potential consequences? All right, Ms. Wellborn, does your client intend to enter a not guilty plea at this time?
That is correct.
Okay, then Ms. Salerno, for the record, how do you plead to the charge?
Not guilty.
I'll take a not guilty plea. Has a legal defender been appointed in this matter?
I think she wishes to retain, Judge.
Let's talk about that. Miss Salerno, is it your intent to retain private counsel in this matter?
Yes.
Okay, do you, I'm not asking you to tell me who you're going to retain. I want to make sure that you've thought the matter through. Do you know who you are going to retain?
Yes, I had an appointment already scheduled for
Okay.
the 30th of this month, so
Okay.
maybe I can get it.
That's fine. The reason I ask is sometimes when people intend to retain private counsel, then they don't know what to do next, and then they come back for their next date and they've actually been unrepresented. So I just always want to make sure somebody has a plan in place before we proceed. You have a plan in place. Let's discuss conditions of release. Let me hear from Ms. Gianoli first, please.
Thank you, Judge. And again, I must apologize. This was the matter that I had pulled up when I was addressing the prior domestic related case.
I understand.
Thank you, Judge. In any event, the defendant had called 911 reporting a domestic disturbance. When law enforcement arrived, she indicated that there was only a verbal altercation between she and her prior significant other. The two had a prior dating relationship. They share 2 children in common, 8 and 11 years old. When law enforcement contacted the alleged victim, he was confused as to why law enforcement was currently there and indicated that the two of them had had an argument 4 days prior in which the defendant had punched him in the nose back on September 26th. He then produced a photo that was date stamped, which showed him having a little blood around his nose and some injuries consistent with his assertions. He indicated that the defendant was upset because he had been communicating with an ex. She attempted to grab his phone and ultimately battered him about the face, took a hammer thereafter and began destroying surveillance cameras in the yard. He was able to provide a video to law enforcement to corroborate this later assertion. Defendant indicated that she likewise had had an argument with him. The two had struggled over a phone, and she indicated that she had, quote unquote, began swinging at the defendant. As she was being arrested, she spontaneously stated that she had not struck him in the face, but instead struck him in the chest. Your Honor, she has no criminal history. Her court services indicates that she is a low risk at a level 4. That stated, I do have concerns and believe I've met my burden that she poses a risk to the community given the allegations of violence, as well as her admitted involvement in those allegations of violence. I am taking the fact that she is low risk, Judge. I am asking for a reduced bail in light of the circumstances. I'm asking for $750 bondable in this case. Should she be released, conditions that she obey all laws, consume no alcohol or drugs, and have absolutely no contact in any way, shape, or form with the alleged victim. I'm not seeking any sort of testing, Judge. She doesn't have criminal history to support it, and there's no indication of impairment on this date.
Okay. Ms. Wellborn, please.
Thank you, Your Honor. I do want to state that we understand the state's burden and needing to show these factors, but that, you know, we're here for bail. We're here for this determination that she has the right to a trial, and we're not here to litigate the extent of the facts of the case and accept them as true. In this instance, she is hiring counsel. We understand that she has been accused of something grave, that success on the merits of the case is one of many factors to consider in determining her pretrial custody status. Understanding that this is a serious charge, she does have the ability to pay a small amount of money. She has 2 children to return to.
Thank you for the follow.
She does reside with the alleged victim. However, she can live with her mother. We called her phone number on her NPRA score. She did receive a point for not having a working phone number, but she just didn't have her phone on her. But she has a working phone number, so reliable means of communication, a reliable place to stay with her mother as she goes through these proceedings. But understanding that the court may want to see some financial guarantee that she does not pose a risk of harm to the community, and that she will appear in court $1,000 bondable would be a reasonable bail setting in
Hey,
this
thank you,
instance.
Chantel.
I do find that the city's met its burden by clear and convincing evidence to show that monetary bail is appropriate. I agree with both Ms. Wellborn and Ms. Giannoli herself that
What's
a
up, guys? Let's
reduced
get up to
amount
50,000
seems
taps.
appropriate
We're
given the
4,000
nature
taps
of the
away.
allegations, given the lack of criminal history, given the relative low risk, and given her ability to navigate the criminal justice system through private counsel. I have a pragmatic question before I finalize the amount. Over my years doing this, I am aware that the minimum amount that a bail bondsman will actually issue a bond has steadily risen over time. I would normally think that $750 is a good amount here, but I'm not sure she can get a bail bondsperson to come out, and I don't want this to turn into a functional cash bail.
Give her $1,000.
Based on, and counsel, this is to both of you, based on what you're seeing out there, do you think we can get a bail bondsman out for $1,000?
$1,000 would be
And Your Honor, I
10%,
honestly,
plus collateral.
maybe the deputy could help us with this one. I don't.
Deputy, if you don't mind, I'm just trying to inquire because I want to.
What is that lady?
I want to get an amount where a bondsman actually will come out. I know they'll come out for $1,500. If they'll come out for less, then I would be fine with less. But I don't want it to become an unintended trap for the unwary.
No collateral in Nevada.
That is beyond my scope of information.
Not a problem. I know that $1,500 will result in a bail bondsperson coming out. I'm gonna set it at $1,500 on that basis. So I want the record very clear that I am setting it at what I believe to be the least amount that will actually result in a bond being written to allow her to functionally secure release on a bondable bail amount. Had I information that the amount would be lower, I would be inclined to order a lower amount. I just want the record clear on that point so it doesn't look like I am raising the amount above what the city asked for and above what Ms. Wellborn asked for. That's not the case. I'm just trying to get an amount that actually will result in a bond. Should she be able to post bail, obey all laws, no drugs and alcohol, no testing regime will be ordered. Just stay sober, stay in your right mind, and no contact at all, directly or indirectly, with the alleged victim in this case. Anything further on this matter from the city?
No, Your Honor, thank you.
Ms. Wellborn, anything further on this matter?
No, Your Honor.
All right, that's court's order, and that takes us to Renee Shepard, please.
Renee Shepard.
Oh, Judge.
You're it now.
Pardon?
Public pretender, the PD.
I think she was saying thank you to you.
Oh, best of luck to you. You are welcome.
Renee Shepard, come on. Damn.
Renee Shepard, how are you doing this morning?
Good morning.
Good. You doing okay?
I'm all right, thank you.
She don't look
All right, we're here in 25 CR 09108. This is an underlying trespassing case in violation of Reno Municipal Code 8.10.010, coupled with an alleged failure to appear in violation of Reno Municipal Code 1.04.080A. Ma'am, at the beginning of these proceedings, did you have a chance to speak with Ms. Wellborn?
Yes, sir.
And so you got your rights explained to you, your options, potential consequences explained to you today?
Just about, yeah.
Okay. Do you have any questions about these proceedings?
No, I just really want to apologize for missing.
Yeah, we're going to take it one step at a time, and ma'am, and I will listen to you. Don't worry. You will absolutely have a chance to address me if you want. Although I'm sure you heard me earlier say it's not always the best idea to do so. But step one, on the failure to appear, do you admit or deny that you failed to appear for proceedings in this court?
Well, I don't know what we're doing with, I don't know what we're doing.
So you have a trespassing case in the Reno Municipal Court. Are you aware of that, ma'am?
Yes, sir.
Okay. And that matter was set for a hearing. Are you aware of that, ma'am?
Yes, sir.
And we think that you did not appear for that hearing. Are you aware of that?
Yes, sir.
Do you admit or deny that you failed to appear for a hearing in this court?
Yes, sir. I admit that.
I'll go ahead and take the admission. How long has Ms. Shepard been in custody?
She has a total of 3 days.
I find that time served is sufficient on the failure to appear warrant. Ms. Wellborn, are we going to square up on the underlying trespassing charge today?
Yes, and I'm hoping that's not affecting the time served. But yes, she's wanting to resolve that matter today, Your Honor.
All right, then Ms. Shepard, to the underlying charge of trespassing, how do you wish to plead today?
Guilty.
Okay, I'll go ahead and take a guilty plea.
She looks Amish now.
Let's talk about I think we can proceed to sentencing today, Ms. Gianoli. Is that correct?
Yes, Your Honor.
All right, let me hear from the city first. Ms. Wellborn, I'll hear from you. And just to reassure you, time served is still on the table. I'm not extinguishing all 3 days on the warrant. I'll see what the facts are that move me to figure out what justice requires. Ms. Gianoli, please.
Your Honor, here the defendant was at the Riverwood Apartments located at 755 Coonsley. According to the statement provided by the employee of those apartments, they indicate that they've had ongoing issues with the defendant. She continues to return. Court services indicates, Judge, she was released from prison in 2024 and that she has a history of nuisance offenses and failures to abide by court order. Judge, I worry that if we don't do a suspended sentence, she's going to continue to go back to that premises. I am asking for a reduced suspended sentence here. I'm asking for a 15-day suspended sentence for 1 year. Conditions that she obey all laws, consume no alcohol or drugs, and stay away from 755 Coonsley Avenue, please.
Did she say 5'5"?
Ms. Wellborn.
Your Honor, we're asking for time served in this matter as well to be served concurrent with her failure to appear. She, can
Southern, thank you for
can
the
stay
follow.
away from the premises. She has some. I don't think that the sentence is necessary given the nature of the sentence. She has some things going on in her life that are going to keep her focused and ready to move forward and out of trouble. She has a job at Blackberry Diner where she's been working for the past, I put 3 weeks, but was it 3 months?
3 weeks.
Yeah. So, and she's really enjoying her job there. She has a child to get home to. So I don't think that the suspended sentence is
3
necessary
weeks
in
is
this
a
matter.
good-
Time served is appropriate.
All right. Ms. Shepard, the law affords you an opportunity to address the court prior to imposition of sentence. You're not on the spot to make any sort
I've
of
been
great
working
big
for the
speech,
last
but
25 years.
if there's anything you'd like to let me know, now is your opportunity to do so.
I definitely understand I was irresponsible to miss the court date, and I do apologize that in my timing and my schedule. It was a series of unfortunate events that showed not, swell on that end. But I
Does she
mean,
only
I
have
don't
one
believe that
tooth?
the suspended sentence is necessary because at the time I lived at Coonley Street and I had an apartment there, but I've been moved out of there for the past 2 months actually. Since I missed the court date, I've actually been moved out of there. I moved back with my mom.
Working.
At the 1000 El Rancho, which I was just stating that my mom's in Vegas right now, and my kid is with my neighbors because he was under my watch, but my mom is his guardian, but she won't be back till for
She
2 more
covered their
days.
bases on that one.
So between my sister and my neighbor right now.
Okay.
But I definitely understand that they don't want me at their premises. I don't want to be at their premises. I no longer live there. And I definitely respect that they don't want me there. And I can assure you that it won't be an issue.
Restraining order? Did somebody say restraining order?
I do think that a short suspended sentence is warranted here to ensure that you stay away and that you are otherwise obeying all laws. I am going to order as follows: 10-day suspended sentence. I will give you credit for time served for the 3 days that you spent in custody as against that 10-day burden. I will suspend that for a period of 6 months. I will order that you stay away from Kensley, and I will order that you obey all laws. I'm not going to impose the no drugs, no alcohol. This doesn't appear to be an alcohol-related offense. I don't have the facts sufficient to find that that's going to be a worthwhile
It means that she's not going to go to jail.
Of suspended sentence, although sobriety is always
that amount of time.
a better choice. I'm not going to order it.
So she'll do 7 days.
10 days suspended, 6 months, obey all laws, stay away from Coonsley, stay out of trouble for 6 months, and then you're going to be able to put this one behind you. And I go to Blackberry Diner with my kids an awful lot, so maybe I'll see you down there, and I'd be glad to see you and shake your hand in person if I meet you. Sometimes life knocks us down, and hopefully this is that turnaround moment for you, and we get back off on a better foot. And if I see you out in the community, I'd be delighted to make your acquaintance, ma'am. I wish you absolutely all the best of luck out there, especially taking care of that kiddo.
He might need to be checked out by a professional.
That's going to take us to Arthur Stabilito, please.
I wouldn't want to see any of these people on public. Judge loves the.
Good morning, sir. How are you feeling today?
I'm very well, thank you.
Good. We are here on looks like 2 matters. I've got 25 CR 14660, an allegation of resisting a public officer, and it looks like a pretty aged case, 18 TR 18729, driving in excessive posted speed in a school zone and driving without a valid driver's license. First things first, Miss Giannoli, do I understand correctly? I've got a 2018 case here.
You don't come out of this gated community.
Okay, and I don't seem to have a failure to appear or warrant in front of me. Okay.
I didn't see one.
That's okay. We'll pick it up in just a few moments.
I'm also
seen a 2018 case since about 2020. But we'll get there when we get there. Mr. Stabilito, at the beginning of these proceedings, did you have a chance to speak with Miss Wellborn?
I did.
Miss Wellborn, what are we doing here today?
So he needs to be arraigned on the resisting charge, and he intends to enter a not guilty plea.
Okay.
And then of course we will discuss custody status.
Yeah, let's take this. Normally I like to try to handle cases combined. I'm going to do this one at a time. So let's pick up 25 CR 14660. Sir, this is your time and place for arraignment on a charge of resisting public officer. You understand the charge against you, sir?
Yes.
And you've had an opportunity to consult with counsel, correct?
I have, yes.
How do you plead to the charge?
Not guilty.
Okay, I'll take a not guilty plea on the resisting a public officer. Let me hear from the city on potential release.
Judge, in candor to the court ordered an OR here, and court services sent an email indicating the defendant refused OR and wanted to speak to you. So I'm going to defer to your honor here.
Okay, Ms. Wellborn, do you have any?
So we got to talk about that this morning, and he has been advised that it's best for him to consult with his attorney on any defenses in this matter, and that they will be addressed through the regular processes of the courts. And that's what's in his best interest.
I understand.
We'll gladly accept that OR.
Yeah, and I will reassure everyone I am not going to second guess the prior OR, just like I generally don't second guess prior bail sets. So own recognizance is going to be ordered. We'll set this matter for trial. Was a public defender previously appointed, or a legal defender? I apologize.
No, Your Honor, we can set that right now if you wish.
Yes, please. Let's get this on the LD docket, get an LD staffed up, and get a trial date, please.
Thank you, Your Honor. That would be November 13th at 1 p.m. with Mr. Puentes.
Perfecto. Thank you. And then that takes us to 18 TR 18729. I have this as an arraignment. Is that correct?
Yes, Judge.
All right. Mr. Stabilito, you are charged with the speeding in excess of posted speed in a school zone and driving without a valid driver's license. Have you had a chance to consult with Ms. Wellborn on this matter as well?
I have no idea about this case.
Yeah, Your Honor, it wasn't on my.
These people don't know anything.
Listed, and I don't think we're appointed to it.
I don't even remember this happening.
Okay, hold on.
It's from 2018.
A little suspicious.
I can do two things. I can do two things here that I know I can do, and I'm willing to entertain other thoughts. Number one, enter a not guilty plea, consolidate this matter with the other case so it can trail, figure out what's going on between now and time of trial. Would seem to be the most efficient. Number two, if he is truly uninformed of the charge and cannot intelligently enter a plea at this time, perhaps I can continue the arraignment on this matter to the date that was set for trial in the other matter. Those are the two things I can think of off the top of my head procedurally, but I'm open to other alternatives, of course.
I'm telling you, this fool looks like
Mr. Noli,
what up, Becca?
I apologize for putting you on the spot, but I think we're all looking at the age of the case. Is this a case that the city intends to pursue?
It's something that's viable, Judge. Diamond is still available. Somebody did sign the complaint. I don't know if it was the defendant or not, but the officer is still around, Judge. So it's still a viable charge in my mind.
Not a problem. Absolutely so. Ms. Wellborn, then, do you want a few minutes to talk to Mr. Stabilito to decide whether he wants to enter a plea at this time or whether it makes more sense for me to continue arraignment?
Yeah, but let's have a quick discussion.
Yeah, absolutely. If I can go back to the waiting room again, and then we'll pick it back up.
All right, guys.
Thank you, Renard.
They're gonna have a private discussion. Let's give them some privacy, if you will. All right.
I apologize for that, Arthur. I didn't know that they were going to address the traffic offenses today, so that's why
I honestly I can't even remember
about them. Yeah, it's just from 2019. I want to look at the.
Does it have like street names or like where?
Hold on. I'm looking at the complaints. I'm looking at your citation to see if you in fact signed it. So let me do that first for you.
Chicago.
Because if you did in fact sign it, it's probably within your interest to,
Mark, thank you for the
potentially.
Mark.
enter
He
your
sounds
not
like
guilty
you, James.
plea.
That fool don't sound like me.
So it was Stephanie to Arthur.
He's guilty.
Driving without a valid license, $350.
Trish, I love this.
Let's make sure we got the right.
Hey, Alexis, thank you for the follow. Highly appreciate you.
Did your car in 2018 have California plates?
That's likely, yeah.
Okay,
It's
date of
likely.
birth 10/30/87.
That word's not
That's
even
me,
my
yeah.
vocabulary.
Okay, just making sure that that's
Does it say
you.
what school it was
And
in
then we
front
got there is a signature here, and it says Diamond, print name Diamond.
Diamond.
Oh, no, that's the officer.
What?
This is defendant's signature.
Hey, Bern, thank you for the follow.
I mean, it
Kelly,
is
thank you for the follow.
signed.
Kristen, thank
Does
you
it
for the
say
daily
what
heart.
school it was in front of? Maybe that would
Ellie,
jog my
thank you for the
memory.
daily heart.
Speeding in a school zone.
The scoundrel. How dare you speed in a
Defendant
school
observed
zone?
driving near Rob from Lancer.
Nevada,
Speed of 35
Jennifer.
miles per hour. Active school zone.
Kimberly, thank you for that daily
Save
heart.
school.
That actually is that probably did happen. That jogs the
That probably
school
did
up by
happen.
Rob, like just past it, or not past it, but you take the Rob exit and it's out
Okay.
that way.
So, I mean, you've
Anna,
got
thank you
the
for the
speeding
follow.
ticket, which,
Teresa.
it's a pay, you got to pay for it.
Right.
And then if you can show that you have had a valid license at that time, or that you have a new license, they could either dismiss the charge or reduce the fee.
Hey, what up, Bill? Cool things.
Okay.
Okay, so I mean, you can plead today, take care of it, and then be sentenced to go and pay your
Free
ticket.
housing, right, Joe?
Yeah, let's just do. I mean, I should have done that a long time ago. I apologize for.
Okay, no problem. And I'm sorry that I didn't have it on my
No,
list.
it's okay.
We're
This is
ready.
unexpected.
Thank you.
Well, this is a private conversation. This is a conversation between the attorney and him. And obviously us right now watching on social media. Oh.
Hold on one sec. You guys just beat me back to the punch. Hold on.
Don't you worry, Your Honor. Don't you
All
worry.
right, Ms.
Hey, what up,
Wellborn,
Kelly?
you have a chance to consult with your
What's with
client?
the
Yes,
afro?
he's ready to enter a guilty plea to that traffic.
Oh, okay.
Oh.
Sir, then in 18 TR 18729, 2 counts speeding in excess of posted in a school zone and driving without a valid driver's license. How do you wish to plead at this time, sir?
I'll plead guilty.
Guilty as to both counts? Okay,
Yes.
I'll accept guilty pleas on both counts and convict you accordingly. Ms. Giannoli, are we prepared to move forward to sentencing at this time?
Yes, Judge,
I
given the
always
age of the
wanna hear it
case,
like
I'm
that.
seeking time served.
Oh, okay. In that case, Ms. Wellborn, any
Zebra was
response?
singing.
No, that's great.
Okay, and then Mr. Stablito, the law affords you an opportunity to address the court before I impose sentence. The city's looking for time served. That would be my inclination as well. Anything further you'd like to add to these proceedings?
No, and I thank you for that.
Okay, well done, everyone. That is going to be time served on this one, and that concludes our in custody docket, subject to a few end of docket
Your
matters.
Honor,
Clean.
there was 2 charges on that case. Is he pleading guilty to both the speed and excess and the driver's license?
Correct. He pled guilty as to both counts and
It
time
looks like he's
served as
working
to
from
both
home.
counts.
Thank you very much.
Of course. All right.
Active. What the what?
Gilstrap.
I didn't hear that. Just
Uh,
right now. Who's this officer right here? Can we get
End of docket for Gilstrap. What's going on?
We need a comp eval on Mr. Gilstrap. He was unable to communicate this
Gilstrap,
morning.
you say?
And I think just, this sort of the nature of what's happening and all of these trespass charges indicate that he may not be competent to.
When you say unable to communicate, what like aphasia?
Very erratic, very
Okay.
erratic. Couldn't answer questions directly.
Okay.
Really did not have an apparent understanding of what it was that I was talking about with any questions that were asked of him this morning.
Okay. I think an in custody competency evaluation subject to a no bail hold is warranted in this case. That's going to be court's order subject to any further comment. Nope. Okay. That is court's order. And then that takes us to, what was her name? Paschetti, please.
We are also requesting a competency evaluation in these matters as well. I mean, it's unfortunate to make people stay there and wait for these evals. And of course, we need to get it done, but she was not able to identify who the president of the United States was. She thought the year was 2011. She didn't seem to understand the charges against her. So I question her competency to move forward.
Hey,
Thank you. I
her
appreciate
mind
the
is
candor. In
saving
all
herself.
candor, I sometimes
2011
have
was
the
a good
same
year.
sympathetic view that it does seem a shame to hold
You
people
could buy a
who
house, affordable house
just
back
maybe
then,
need a little bit of
2011.
extra help. Sometimes I mollify myself from that thought with the idea that if
I ain't
people
mad at
are
her for being at
incompetent, sometimes
2011.
maybe it's better if they are in the care of somebody else, even if it is an unpleasant venue such as the jail. An incompetency evaluation in custody will be ordered subject to a no bail hold until it is complete. That takes care of Ms. Pischetti. Was it Travis Hall that was here and then went back? Travis Hall?
How is the filter allowed?
I think you saw him, Judge. He was the community court guy that
Never
owed the
mind.
8 hours of community
Oh,
service
that's right. That's right. That's right.
post.
Your Honor,
My
I
son
think
was
the only
born in
one we have left
2011.
is Norman Malos.
Yes.
And I am in possession of a competency evaluation dated the 30th. Let me just review
This
it
judge
very
plays too
quickly.
much. How dare he go to court with a filter?
Okay. And then as I look at the recommendations, does not appear to meet criteria for competency, does not appear substantial probability
Leanne, thank you for the
that they
follow.
will attain competency, and due to
What up,
mood
Lexi?
and agitation appears to be a danger to himself and does appear to be a candidate for civil commitment to NAMS Inpatient
2011 was the
Psychiatric
perfect year to buy a
Hospital.
house. If you
Any
wanted to
further
buy a
comments
house.
from the city on this matter?
Yeah, and I'm likewise in receipt of that evaluation and reviewed it. All is that is accurate, Judge. I am making a motion to dismiss without prejudice these matters, given the evaluation's
what up, Jenna?
notation about him in need of civil commitment.
A month
I
later,
am
she
asking the jail
evaluation
pursue
update.
that if appropriate.
Thank you, Ms. Wellborn. Any further things for Mr. Malice?
No, Your Honor, no
Okay,
objection.
that's going to be the order of the court. Matter is dismissed. I will ask the court to the jail to evaluate him for civil commitment to NAMS.
Civil commitment?
I believe that is
That's a
everything
crazy
we had on this docket. Is that correct?
So,
I
Your
think
Honor,
so, Judge.
thank you.
All right. Thank you, everyone. Have a great day.
Hey, have a
Thank
good
you.
one. All right,
Take
we're gonna
care.
be going
And
over
then Ms.
to-
Massey, if you and Ms. Gonzalez can stay on for just a few seconds, I'd appreciate it.
Okay.
Nice
no
to
worries.
meet you, Holly, by the way. Good to see you.
Too.
Take care, everyone.
And I just
Hey,
wanted to
Angie?
say, Judge,
Yeah.
if I may, that I really appreciate the thoughtfulness on the custody determinations and the time that you offered for me to clean some of that up and just the thoughtfulness that went into it. So
Thank you. I do appreciate
They cut it. Hold on. Let's switch it up right now. Civil commitments, you're going to the nut house, the crazy house. Put in a straitjacket, if you will.
I don't see Mr. Booker's name anywhere in the interim complaint. It also appears in the final paragraph of the interim complaint that whoever is alleged to have shot the victim was also somebody who carried him outside, which it looks like all of those people are named. So I don't see anybody identifying Mr. Booker. I don't see Mr. Booker being interviewed and giving statements. I don't see Mr. Booker being found with a weapon. I'm struggling to find any probable cause given what I have in the interim complaint. His name's not even mentioned. No one says he was even there that night.
So we did get clarification from liaison here today in terms of Mr. Booker's involvement in this case. So he was able to review the reports and talk to the assigned detectives so that I could find probable cause, and I will find probable cause based on the information that he was able to provide this morning.
I'll defer to the court, Your Honor.
Do you guys think Mr. Booker is guilty? Is he guilty or not? Mr. Booker. Seeking Mr. Booker on this.
So, Mr. Marsh, we're going to make sure that the liaison officer that's here does add the information he provided to the interim. So that'll be provided to all the parties so that you do have the information that I was provided this morning from Mr. Booker. All right.
Understood.
All right. With that, I am going to impose a bond in this case. It is going to be a $50,000 cash or secured bond.
Damn,
Mr. Booker, if you post that bond, then you'd be released to pretrial services. You're going to have to participate in any monitoring or treatment that pretrial services directs. You're not allowed to possess or consume any alcohol or illegal drugs, and you're not allowed to have any firearms in this case. Don't have any contact with the victim or return to the incident location. Do you understand all those conditions of release?
Yes, ma'am.
Your next court date is October 13th at 1:30. That's a preliminary hearing. That court date may or may not occur, but you are expected to show up at all future court dates. And if you fail to appear, they could issue a warrant for your arrest. Do you understand the consequences if you don't show up for court?
Yes, ma'am.
You're all done for today.
Just for given up school. So you're being held. It's your public info names. Brian.
All right, here we go. Let me see. What was the charge? Sounded like it was like shooting somebody.
Hey, sir, tell me your name.
Eric Fry.
Mr. Fry, you are here on felony charges for drug paraphernalia and drug possession. The good news on that one is it looks like the state is moving to dismiss those charges at this time without prejudice. Mr. Poston, is that correct?
Yes, Your Honor.
All right. So that case
like
is
they're
being
training a new judge.
dismissed, so we're not going to talk about that one, but you do have other matters that we do need to talk about here today. Looks like you do have a misdemeanor warrant for your arrest out of Pima County Justice Court for obstructing a highway. That is a misdemeanor. It occurred back on May 17th of 2025. And then there are also some Tucson City Court matters that looks like that you have failed to appear for, involving the same charge, obstructing a highway, soliciting, and then other matters involving drug paraphernalia, criminal trespass, lots of files. So, Mr. Fry, I'm showing a general delivery address for you at this time. Is that still your
for that. Highly
circumstance?
appreciate you.
Are you
Shannon,
housed?
what's
Are you
up,
housed
Shannon?
at this time or unhoused?
I'm on this.
Okay. All right. If I release you on your city court cases, I'm going to give you some information to get to the transition center. Will you cooperate with them and have someone help get you to court so you can get these matters taken care of?
What type of cooperation are we
So I'm
talking
going to
about
give
here?
you 2 different court dates. I am going to release you on the justice court case. That court is going to be October 22nd at 11 o'clock in the morning. You do need to
selling
get
himself,
downtown to
soliciting.
Pima County Justice Court on that date and time. If you don't, Mr. Fry, they're just going to keep issuing warrants for you. Do you understand that?
Yeah.
All right. And then on your Tucson City Court cases, I'm going to release you on that case and those as well. This is also the time for your arraignment on those charges. We're going to enter not guilty pleas on your behalf, and you are presumed innocent. Your next court date that we're going to give you for all of these cases is going to be October 29th at 2 o'clock in front of Judge Mayhew. You do have to appear on the 29th at 2 p.m. at Tucson City Court. If you don't, they're going to issue more warrants for you. They could also go forward with that hearing in your absence and set future hearings in your absence, including a trial. If you get convicted at that trial and can't be sentenced within 90 days, you could lose your right to a direct appeal. Do you understand all of those consequences if you don't go to court?
Yes.
All right. When you get released today, you're going to get 2 pieces of paper, one for your justice court case and one for your city court case. Make sure you have those because it's going to have the dates and times I just gave you. Now for the transition center, Mr. Fry, when you get released today, as soon as you walk out of the door for the jail, look down and follow the blue line. That will take you to the transition center. And there are people there that work as navigators that can connect you to services in our community, including helping you get a ride to court if you need to. They just need to be able to provide those services. They could also help you with housing or other services if you're interested in doing that. So please make sure you at least stop by on your way out of jail today and talk to them, okay?
And meanwhile, I can't even buy a dozen eggs.
You're all done for today.
He must be
Lisa.
Make that make sense.
I'm just not used to them coming back this way.
Next on the
Hi,
Price
ma'am.
is
Tell me your
Wrong.
name.
What do you guys think she did?
Ms. Harake, you are here today on a few different matters. The first is a warrant out of Pima County Superior Court for failing to appear for your initial appearance and arraignment back in August of 2024. No, that should be, yeah.
Hey, thank you for the, it's
The
Kiki,
offense
thank you for
happened
the
in
follow.
August of 2024. You failed to appear August 26th of 2025. You do have the right to remain silent. Anything you say can and will be used against you. You do have the right to an attorney. We're going to appoint the legal defender's office to represent you. The charges are a felony theft and also a felony shoplifting charge. The amount on the warrant is $1,500. I am planning to impose that amount. That is what the state has. We also need to talk about some Tucson City Court matters. Mr. Poston, did you need to be heard further?
No, Your Honor.
Mr. Marsh?
Nothing further, Your Honor.
All right.
Thank you.
So, ma'am, you're going to be held on that
They're training that judge up
$1,500
next to
cash
the
or
judge.
secured bond. If you post the bond, you'll be released to pretrial services. You do have to stay in contact with that agency as directed, participate in any monitoring or treatment they direct. You're not allowed
Queen
to
Peach,
possess
thank
or
you for the
consume
follow.
any alcohol or illegal drugs, and you can't have any firearms while the case is going on. You're also not allowed to return to where the shopliftings occurred. That's the incident location. There are victims
it.
there and you can't have contact with them. Do you understand all of the consequences
Not it.
or all of the conditions that I've just given you?
Hey, what up, Nicole? Thank you for that.
Answer out loud. Okay. Your next hearing is
Thank you,
going
Carl.
to be your arraignment in this case. That's going to happen on October 9th at 1:30.
He is
That
magically
is at Pima
disappeared.
County Superior Court. If you do post your bond and get released, you are ordered to appear at that date and time or they'll issue another warrant for your arrest. If you remain in custody, the jail will make sure that you're seen via video, much like you're doing here today for that hearing. We do need to talk about your Tucson City Court cases. You're here for warrants out of Tucson City Court for contributing to the delinquency of a minor, drug paraphernalia, and criminal trespass. You do have the right to remain silent on those as well. On those charges, I am going to release you. I am going to appoint the City Public Defender's Office to represent you. And we're going to set what's called a non-transport future. It's going to be November 21st at 9 a.m. And that will be at Tucson City Court in front of Judge Cranshaw. Do not return to where the trespass occurred. That's where the victims are in that case, and you can't have any contact with them. You'll have someone from the City Public Defender's Office that will be contacting you while you
I'm
are
like
in
Wilson
custody,
from Home Improvement over
and
here.
they will help you navigate your city court case. We're setting that date out a little ways to give your felony case a chance to
None of
kind of
your
move along
business.
before you're
405,
dealing
thank you
with
for the
your
follow.
city court matter. You do have to appear, though, if you do get released, or they're
Which
going to
guy,
issue more
Tasha?
warrants for you. Do you understand the consequences if you don't
At
go to
what time?
court? I need you to answer out loud.
Yes, I do.
Okay, you're all done for today.
This thing has a mind of its own. Josh, thank you for the follow.
Hi, tell me your name.
Oh, got
Pedro Howdigay.
Mr. Hodegui, you are here today on a warrant out of Pima County Superior Court for dangerous drug possession, narcotic drug possession, and drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You do have the right to an attorney. We're going to appoint the Public Defender's Office to represent you, and you do have counsel seated with you for purposes of the hearing here today. We're here to talk about your conditions of release. It looks like you also have a warrant
Laura,
out of
thank you for the
Maricopa
follow.
County that we're going to talk about here in a moment.
$5 grand for the
In
people
this
that
case, there is
message
a
you hard times.
$5,500 cash or secured bond
they
on the
should put
warrant.
5,000 over here,
It is
eh?
my inclination to impose that bond today. Mr. Poston, did you want to be heard further?
I got nothing. Let me
Me?
help you out
No.
here.
No, Your Honor.
All right. Mr. Marsh?
I would just note one thing briefly, Your Honor. It looks like these two cases are his only history, and it looks like, at least for the past 5 years, he stayed out of trouble. I understand, 6 years for the Maricopa case. I understand the court's concern. He's got this warrant on what appears to be a more serious case coming out of Maricopa. His father did agree to have third-party custody. If the court would entertain giving Pedro the chance to get these cases resolved, just because of their age and the lack of law enforcement contact since, I think that he might be successful if he's released getting these resolved on his own.
So I am going to impose the $5,500 cash or secured bond on the Pima County case. If you do post that bond, then you're going to be released to pretrial services. You do have to stay in contact with that agency. You're not allowed to possess or consume any alcohol or illegal drugs. You do have to participate in any monitoring or treatment they direct, and you can't have any firearms. Your next court date in that case is going to be October 9th at 1:30 in the afternoon. That is your arraignment. If you post your bond, you are expected to be there on your own. If you remain in custody, the jail will make sure to have you appear either via video or transport you to the courtroom. But if you fail to appear, they can issue a warrant for your arrest. Do you understand the consequences if you don't show up to court? All right, now we do need to talk about your Maricopa County warrant now.
Tucson, or no, I didn't see Tucson court yesterday. I missed it. At what time? The nighttime one or the
there's
daytime
a
one?
$7,500 bond amount on that case. I am going to impose that $7,500 cash or secured bond there as well.
I'll have to check it out.
What we're going to do is set a review hearing for you here on November 4th at 9 o'clock in the morning. What'll happen, sir, is if you remain in custody here, they'll likely have you stay here until you get your Pima County cases resolved. If you post the bond, you're going to be held on that Maricopa case, and then the jail would contact Maricopa and let them know they could come pick you up. If you end up posting bonds on both of these matters, you do need to contact Maricopa County so that you can get the matter resolved up there, and then you still have your court dates that you need to be mindful of. I'm setting a review hearing for you date for the Maricopa case for November 4th at 9. If you're still in custody here on your Pima County cases, you'll appear just like you're doing here today for that review hearing, so we can figure out what's going on with your Pima County case and make sure that whenever your Pima County case is done, that you can be taken to Maricopa County if you do remain in custody. Do you understand all of that, sir?
Yes, ma'am.
All right, you are all done for today.
So this is your arraignment. This is the review.
Spoke at 11 as Maricopa. Same. It might be chat. Sometimes they do it at 10, sometimes they do it at 11. It just varies.
Say the pre-call services.
What up, Mona?
Well, do take care.
Yeah, I don't think he's gonna get the one.
Okay, that makes.
I
'cause
noticed
knew
something
I saw
with these
his name in there
filters.
somewhere, and that's why I was really confused. Okay. Well, I'll
If you're
just sign
lighter,
both
you're
of
more-
them so
you're
that
more
we
tend
have
to
the
get
information,
detected by
because
the
this is the one
filters.
that has trammel on it, and that's what we needed. Okay, all right, perfect. Thank you. I'm gonna hand that back to you so it doesn't get messed up with all the others. All right, hi, sir, tell me your name.
Yeah, the Reno court is pretty cool. Hey,
Mr.
No, Bob,
Lawson,
thank you.
you are here today on a felony charge of narcotic drug possession for sale. You do have the right to remain silent. Anything you say can and will be used against you. You do have the right to an attorney. We're going to appoint the public defender's office to represent you today, and you do have counsel seated with you for purposes of the hearing.
I'm gonna switch it over to the judge in training.
We're
'cause
here
I
to
don't
talk
get
about
it.
your conditions of
Oh,
release.
they got him. Oh yeah.
I'm reviewing some information that pretrial services provides, tells me a little bit about you and also the circumstances of the
Got him.
offense. I have had a chance to review information provided by the state. It looks
He
like
needs
they're
to feed.
asking for a $15,000
He doesn't have a
bond
pin. It
at
won't
this
go
time.
on it.
Mr. Poston, did you want to be heard further?
Your Honor, there is just shy of 200 M30s packaged in separate baggies for sale.
What?
This individual has an extensive felony record to include several stints in ADOC for related crimes.
ADOC stands for
15,000.
Arizona Department of Corrections.
Mr. Marsh?
Thank you, Your Honor. I would just note that pretrial services had the opportunity to contact Mr. Lawson's aunt, Kimberly. She has agreed to take third-party custody of him. I would ask for a lower bond to
Third-party
offer him a reasonable
custody?
opportunity of release.
I am going to impose a bond in this case of $10,000. That is a
It's
cash or
starving.
secured bond. If you
I
post
don't know
that
what
bond,
M30s
Mr.
are.
Lawson, then you'd be
Oh!
released to pretrial services. If you do get released, you have to stay in contact with that agency as directed. Participate in any monitoring
Maybe
or treatment they direct. You're not allowed to possess or
tablets?
consume any
Pills?
alcohol or illegal
Okay,
drugs,
yeah,
and you
there
can't
it
have
is.
any firearms while this case is going on.
No,
Do you
it has to be.
understand
It
those
has to be.
conditions of release?
I'll
Yes.
agree with what Chad said.
Your next court date is going to be October 13th at 1:30. That's a preliminary hearing. That
Blues, yep.
hearing may or may not occur, but you are expected to show up at all future hearings. And if you fail to appear, a warrant could issue for your
Oh,
arrest. Do
M30.
you
I think that's
understand the
what's labeled on
consequences if you
the
don't
pill.
show
That's
up
what
for
they call it,
court?
M30s.
Yes.
Right?
You're all
right,
done for
Chad?
today.
If you will. M80s are fireworks.
Level.
Hey, thank you for that, Dot. Oh, there it is. Yeah.
Hi, tell me your name.
Daniel Lovell.
Mr. Lovell, you're here today on 2 counts of disorderly conduct with a weapon. They are Class 6 felonies. You do have the right to remain silent on these charges. Anything you say can and will be used against you. You do have the right to an attorney. We're going to appoint the Public Defender's Office to represent you today. I've had a chance to review some information provided by pretrial services. Tells me a little bit about you and the circumstances of the offense. Also had a chance to review the state's recommendation. It looks like they're asking for a $15,000 bond in this case. Mr. Poston, did you want to be heard further?
No, you're right.
Mr. Marsh?
Thank you, Your Honor. From what I'm remembering, I'm trying to pull up the interim complaint for this case. I believe this was a gun flashing case, if I'm remembering right.
What?
Mr. Lovell is barely 18 years old. He's an FTA 1. He's an NCA 2. His father, Jasper, said that he can stay with him, take third-party custody. I think that this is a case where Mr. Lovell needs to be given the strongest possible admonition about staying away from firearms. I think that he is lucky that he doesn't have a criminal history when he's appearing before the court right now. And I think that if this continues, that would likely not be the case going forward. I understand the court's concern if the court's considering a bond. I would hope that this is a wake-up call for Mr. Lovell, and I would hope that if the court would be willing to impose the strongest possible conditions to ensure that he avoids all guns, I would hope that the court would consider pretrial services release.
Judge, the individual's young age is exactly the concern here. This person apparently thought that mere words were enough to escalate into threatening 2 individuals on a basketball court, of all things, with a firearm. This sort of thing is most troubling simply because of the impulse control issues. This person poses a threat. He knew how to obtain a firearm. He decided to consummate the act of threatening somebody by brandishing it. And therefore, the state believes the $15,000 bond is appropriate.
Mr. Marsh, any final words?
No, Your
Also
Honor.
looks like he has a little bit of sugar in his tank. What do you guys think? If you will. What are your guys' observation here?
I am going to impose a bond. It is going to be a $5,000 cash or secured bond, Mr. Lovell. If you post that bond, then you would be released to pretrial services. You're going to be ordered to participate in any monitoring or treatment they direct. You're not allowed to possess or consume any alcohol or illegal drugs,
Am I
and you
only
are
one?
not
Thank you
allowed
for
to
the
have
follow.
any firearms at all for any reason. If you possess or own any others, you do need to surrender those to law enforcement. Your attorney can help you figure out how to do that. You are not allowed to return to the incident location where this happened at all for any reason, and you are not allowed to have any contact with the victims in this case. Do you understand the conditions of release that I've just imposed?
Sure.
Your next court date is going to be October 13th at 1:30. You do have to appear at that date and time. If you fail to appear, a warrant will issue for your arrest. If you remain in custody, the jail will make sure you get to your next hearing. If you post bond and you get released, it is your responsibility to appear. They can issue that warrant. Do you understand the consequences if you fail to appear? Yes?
Yes.
Okay, you're all done.
NBA young boy acting wild.
Hi, tell me your name.
Mr. McDonald.
Ms. McDonald, you're here on a couple of different matters today. The first is going to be a warrant, and then we have some Tucson City Court matters to talk about today. The warrant is out of Roswell, New Mexico.
No, Mexico. In the
Looks
house.
like it's a DUI charge.
Did you say DUI? What?
Looks like there is a bond amount on that warrant of $10,000.
10,000. Area 51. No, Area 51's in Nevada. You're thinking about Roswell, Nuevo Mexico, where that
I am going to impose
unidentified
that
flying
$10,000
object.
bond on your warrant from New Mexico. What we're going to do is set a hearing here on that matter. That is going to be October 7th at 2:30. You do have the right to remain silent, Ms. McDonald, on all of these. Anything you say can and will be used against you. You do have the right to an attorney. We're going to appoint the legal defender's office to represent you in your fugitive matter, and they'll be out to talk with you before that fugitive hearing date. If you post your bond and get released, you need to stay in contact with the legal defender's office so they can talk with you, and then you have to appear on that October 7th date at 2:30. If you don't, they can issue a warrant for your arrest. Do you understand the consequences if you don't go to court? Is that a yes?
Yes, ma'am.
All right. We also need to talk about your misdemeanor matters.
She's fixing her
You're here on
her one fuzzy helmet there.
an assault charge, a disorderly conduct charge. Those are both domestic violence offenses, and
It is a
also a
woman.
DUI.
Domestic violence and DUI?
You do have the right to remain silent on those charges as well. I'm going to release you on those charges at Tucson City Court. Arraignment will enter not guilty pleas on your behalf. You are presumed innocent.
Bearded.
You are not going to be allowed to have any contact with the victim in this case, which is Christian Ornelius.
Poor Christian.
Don't go anywhere near where he is living or
Lights on,
working if
nobody's
you do
home.
post your bond on your felony matter and get released. Do you understand that?
Yes, ma'am.
Looks like your residence is actually here in Arizona. Are you still residing here in Arizona?
Yes, ma'am.
All right.
Is this a girl? Well, I mean, nowadays you never know. So, I mean, based on what I heard, yes. But can I confirm or deny? I can't.
Your next court date in this case is going to be...
She called her Miss. I don't even
Sorry,
see
I'm
a light
pausing because
on.
I want to
Maybe
make
the
sure that you
shade
get your
is
city
pulled.
court matter resolved before they take you on your other case. So, Ms. McDonald, I'm actually going to impose a bond on your misdemeanor case as well. That's going to be a $500 cash or secured bond. So I'm not going to release you on that charge. So it will be $500 cash or secured. Same conditions if you post that bond. Your hearing will be in front of Judge Million, and that hearing is going to be October 15th at 1:30. If you post your bond, then you're going to have to make sure that you appear at that same
Who's
date
Angel
and
Reese?
time. in front of Judge Millian. This
Do
is
they
your
just have to post
arraignment.
10%?
You're presumed innocent. We're
10%.
entering not guilty pleas
Women-
for
women
you if
basketball-
I didn't
women's
already
basketball
say
player.
that.
Oh, thank you, my love.
Do you understand the conditions in your
Getting
city case?
my daily breakfast right here.
Yes.
All right.
For anybody
And
wondering.
your next court date, you are ordered to appear at that date and time. If you don't, they could issue a warrant for your
Rachel,
arrest.
thank you
They
for
could
the
also
follow.
go forward with that hearing in your absence and set future hearings in your absence, including a trial. If you
the
get convicted
Bills
of trial and
Mafia
can't be
315,
sentenced within
thank you for the
90
follow.
days, you could lose your right to a direct appeal. Do you understand all of those consequences if you don't show up for court?
Yes.
All right, you're all done for today.
Mesa?
Hi, tell me your name.
Joshua Mesa.
Mr. Mesa, you are here today on charges of dangerous possession and drug paraphernalia. These are felony charges. You do have the right to remain silent. Anything you say can and will be used against you. You do have the right to an attorney. We're going to appoint the legal defender's office to represent you today, and you do have counsel seated with you for purposes of the hearing. I've had an opportunity to review some information provided by pretrial services. Based on the nature of these charges, Mr. Mesa, you may be eligible to participate in a pre-indictment diversion program. It's called STEPS. And if you successfully complete drug treatment and you qualify for the program, then the state would not go forward with these felony charges against you. Is that something that you're interested in doing today?
Yes.
All right. With that, counsel, I'm going to release him to pretrial. He does have a city court case we're going to talk about. Does either counsel need to be heard further?
I got 2 accounts.
No, Your Honor.
No, Your Honor.
All right. So, Mr. Mesa, you're going to be released today to pretrial services. You're going to have to stay in contact with that agency. They are going to be the one to assist you with getting in touch with other services. So one of the requirements of the program, if you qualify, is to stay in contact with them. So that's really an important element of your release. Do you understand that?
Yes.
All right. You will have to participate in any monitoring or treatment they direct. You're not allowed to possess or consume any alcohol or illegal drugs, and you can't have any firearms while this case is going on. Your hearing to see if you qualify for that program is October 9th at 9 a.m. That will be in Pima County Superior Court. When you get there, when you get to the elevators, look at the screen above the elevators. Look at your name, and it'll tell you the courtroom that you have to go to. Your attorney will be there, pretrial services will be there, and you'll have a chance to review the program requirements and sign up, and there'll be service providers, treatment providers right there in the courtroom to get you connected with services if you qualify. Are we willing to waive time for the preliminary hearing, Mr. Marsh?
Yes, Your Honor.
So what I just asked your attorney, Mr. Mesa, is normally the state would have 20 days to file felony charges against you, but because we're going to see if you're eligible to participate in this STEPS program next week, we're going to extend that time a little bit. So your next hearing after the one next week that you have to go to if you're going to qualify for the program is going to be November 17th at 1:30. That's a preliminary hearing. That hearing may or may not occur, so it's really important that you stay in contact with your attorney. If you don't, they could issue a warrant for your arrest. Do you understand the consequences if you don't show up for court?
Yes.
All right. You're also here for a warrant out of Tucson City Court for drug paraphernalia. I am going to release you on that case today. Your next court date in Tucson City Court is going to be October 31st at 9 a.m. So 2 separate court matters that you need to get to. If you don't show up for that next court hearing at City Court, they're going to issue another warrant for you. Do you understand that?
Yes.
All right, you are all done for today.
Kevin Massa.
Benjamin Molina.
Speaking of masa, I might need to go take a masa pretty soon.
Hey, sir, tell me your name.
Benjamin Molina.
Mr. Molina, you are here
Thank you,
today
Kristen.
on felony charges of misconduct involving a weapon, being a prohibited possessor, and being in possession of a firearm. This is the time for your initial appearance. where we talk about conditions of release. I've had a chance to review some information provided by pretrial services. What that tells me, sir, is that you're on bond and pretrial supervision in another Pima County Superior Court case. As a result of that release, the state has the ability to ask that you be held without bond pending a future hearing. It does look like the state is asking for that. Is that correct, Mr. Poston?
It is.
Mr. Molina, you do have the right to remain silent on this case. Anything you say can and will be used against you. We're going to appoint the public defender's office to represent you, and you do have counsel seated with you today. We're going to hold you without bond. That's what the court has to do when the state makes that request. And your hearing on the no bond is going to be October 7th at 2:30. Someone from the public defender's office will be out to talk with you at that hearing. That will be the time where a judge will decide that you'll either continue to be held without bond or there'll be a bond set. Your next hearing after that on these charges is going to be a preliminary hearing.
What up, Roxy?
That's going to be October 13th at 1:30 in the afternoon. That is a hearing that may or may not occur, but you're expected to show up at all future court hearings. And if you get a bond in the future and get released, you do have to appear. And if you fail to appear, they could issue a warrant for you. Do you understand the consequences if you don't show up for court?
Yes, I understand.
You're all done for today, Mr. Molina.
Pima County. So the flush means like when they normally get like a DUI, domestic violence, something that, you know, puts the public at threat, if you will. What did he do? This dude was discharging a firearm right in public, or he had a possession of a firearm. One or the other, or maybe both. Hey, Jay, thank you for the follow. Highly appreciate you. Damn.
Hi, ma'am. Tell me your name.
Marion Pearson.
Miss Pearson, you were here today
Chrissy, thank
on
you.
felony charges involving aggravated assault, use of a deadly weapon or dangerous
Damn.
instrument, disorderly conduct, recklessly handling a deadly weapon or dangerous
No
instrument.
bueno.
There are 2 counts of those. You do have the right to remain silent. Anything you say can and will be used against you. You do have the right to an attorney in this matter. We're going to appoint the public defender's office to represent you today, and you do have counsel seated with you for purposes of this hearing. It does look like your husband is present. Sir, are you Paul
The
Pearson?
husband's on here.
Right. So we're here to talk about conditions of release.
Let's get the
Mr.
husband
Pearson,
on the
do you
screen
have
here.
information you want to share with the court? Not about what happened. We're not here to talk about that. We're only here to talk about conditions of release.
Yes, ma'am. She's not that bad of a woman. Please be lenient. And also, she does suffer from depression and anxiety. And she is going through menopause right now.
Menopause?
Please.
What the?
I still love her very much.
I love her very much.
Okay.
She's trying to take you out,
Do you
homeboy.
object to her being released today?
No, ma'am.
Okay. What about whether or not, and I don't know that I would do this, but if she
Hey,
was
just think
allowed
about when
to
she gets
return
out. Damn,
home, do
they're gonna
you
get
feel
all sweaty and
safe
messy.
having her
It's gonna be
return
the
to your
best
home?
SEX they've had in a while.
Yes, I do.
There's gonna be a lot of passion going in that room.
And again, it's up to the court to make that decision, but I want your input. You have a right to have that input, and that's what I want today. All right.
A lot of passion.
It looks like the state is asking for a $5,000 cash or secured bond. Mr. Poston, did you want to be heard further?
No, Your Honor.
Don't have that much money, Your Honor.
What?
So we're going to hear from your wife's attorney first. Go ahead, Mr. Marsh.
Thank you, Your Honor. I want the court to note that this person is a 1 on both scales. She's full-time employed. It also looks like the disorderly conduct charges stem from Miss Pearson threatening self-harm with a sheathed knife. This doesn't seem like a situation where the disorderly conduct is she's threatening them with a knife. I would like the court to note she has no criminal history of any kind. I was also speaking with Miss Pearson while Mr. Pearson was speaking to the court. It does appear that she might have housing separate and apart from Mr. Pearson and their shared child. She just needs to make a phone call to be able to establish that housing with her daughter, who does live here in town. So if housing was a concern to the court, Miss Pearson has assured me that she could secure housing elsewhere.
Tucson? Hurricane?
All right. So, Ms. Pearson, I am going to release
Arizona,
you
Frank.
today to pretrial services. However, At this time, I'm not going to allow you to have in-person contact with the victims. So Mr. Pearson, what that means is she's not going to be allowed to return home. She's going to have to reside with her daughter for now.
She's going
You
back
can
home.
have contact over the phone, but you are not allowed to have any contact in person.
How long
So
before
Ms.
they have
Pearson,
contact, do you guys
phone
think?
contact only with your husband and your child, the victim in this case only. Do not go to where they are living or working or back to the house.
They're gonna do.
Do you understand
bump
that?
nasties.
Can we do counseling too, please, ma'am?
So we're going to let Ms. Pearson talk with her attorney, and you guys can arrange to do
What up,
that out in
Kelsey?
the future. All right, Mr. Pearson, there is the Victim Services Division at the prosecutor's office and
I'm
a
in Tucson.
prosecutor that
Damn,
should also
Frank.
be in contact with you, or you can contact
What up,
Victim
Lex?
Services.
Hey,
But
Frank, be
right
careful
now,
out
the
there, man.
court's
It's
order
wild.
is there is only phone contact to be permitted, no in-person contact at this time.
Oh, they're about to do a whole lot of
Ms.
in-person
Pearson,
contacts
you
with body
also,
parts
with
and
being
todo.
released to pretrial services, are going to
Nana,
have to
thank you for the
stay
follow.
in contact with that agency. You're going to have to participate in any monitoring
guinea
or treatment they direct, commit no acts of domestic violence. You are not allowed to possess or consume any alcohol or
Paula?
illegal drugs, and you can't have any firearms while this case is going
A
on. Do you
huevo.
understand that? And do not talk about the incident with each other. You may be allowed to have phone contact, but you shouldn't be talking about this case.
What?
Yes,
Come on,
ma'am.
Your Honor. They're married. Did he?
I'm sorry.
Your next
Not on
court
there.
hearing is going to
Diddy
be
style.
October 17th.
Hey, what up, my lights, Peachy?
That's going to be a preliminary hearing. That's going to be at 1 o'clock in the afternoon. That hearing may or may not occur, but you're expected to show up at all future hearings. And if you fail to
The picture's
appear,
bad.
they can issue a warrant for your arrest. Because you're going to be out of custody,
It
Ms.
is,
Pearson,
Bethany.
it's very important that you stay in contact with your attorney so you don't miss your court hearings, okay? All right, you're all done for today. Thank you for calling in, Mr. Pearson. Thank you for your patience.
Menopause
Have
could
a good
make
day.
it cray-cray?
Thank you, ma'am.
Oh, don't tell me that. Is there any way to fix menopause before it hits? Because, man, there's going to be no bueno. No bueno, I tell you. There, the picture should be better now.
Hi, tell me your name.
Reese, the third.
Luis, you're here today on felony charges of theft of means and burglary. You do have the right to remain silent. Anything you say can and will be used against you. You do have the right to an attorney in this case. We're going to appoint the legal defender's office to represent you, and you do have counsel seated with you for purposes of the proceedings today.
There we go.
We're here to talk about your conditions of release. I've had an opportunity to review some information provided by pretrial services. They prepare a report that tells me a little bit about you and also the circumstances of the offense. I've also had a chance to review the state's recommendation. They're asking for a $15,000 cash or secured bond. I am inclined to impose a $7,500
Josh?
cash or secured bond. Mr. Poston, did you want to be heard further?
No, Your Honor.
She
Marsh?
was nuts?
Nothing further, Your Honor.
Right. Mr. Reese, you're going to be held on a $7,500 cash or secured bond today.
Oh.
Mr. Reese, I need you to pay attention to what I'm telling you today, okay? So the bond is $7,500 cash
You
or
can't fix
secured.
menopause?
If you post that bond, you'll be
You work with a
released to
gynecologist?
pretrial services, and you have to stay in contact with that
Oh, no, I'm
agency.
sweating bullets now.
Participate in any
I'm
monitoring
concerned
or
for my
treatment they
life.
direct. You're not allowed to possess or consume any alcohol or illegal drugs, and you can't have any firearms.
Hormones?
You're also not allowed to return to the incident location or have contact with the victims. If you get released, you understand those conditions.
Yes, ma'am.
Your next court date is going to be October 13th at 1:30. That's a preliminary hearing. That date may or may not occur, but you're expected to show up at all future court dates. And if
Took
you
about
fail
a
to
year?
appear,
I
they
don't
could
think I
issue
could
a
do a
warrant for your
year.
arrest. Do you understand the consequences if you don't show up for court?
Take it easy.
Yes, ma'am.
Right, you're all done for today.
A year, damn. That's like an eternity.
Jail, for Mr. Sandoval, are you showing any kind of hold from federal probation?
Doesn't affect all women the same. Yeah, right, Teresa. Trying to keep me calm. There's
Us?
panic. Panic in
We are
my
not, gentlemen.
eyes.
Okay. All right. Hi, sir. Tell me your name.
Zion Sandoval.
Mr. Sandoval, you're here today on felony charges involving being a prohibited possessor and being in possession of a firearm. You do have the right to remain silent. Anything you say can and will be used against you. You do have the right to an attorney in this matter. We're going to appoint the Public Defender's Office to represent you. I've had a chance to review some information provided by pretrial services. They tell me a little bit about you and the circumstances of the offense. We're here to talk about your conditions of release. I have had a chance to review the state's recommendation. They're asking for a $7,500 cash or secured bond. At
Maricopa
this time,
just started. Do you guys want to stay here? Or do you guys want to go to Maricopa?
Does the state need to be heard?
Let me know in the chat.
No, Your Honor. Other than,
minutes ago.
well, yes, Your Honor. The state would inquire, is there a probation hold from the United States government?
I already did that. The
Maricopa?
answer was no.
Maricopa.
Oh, sorry, the
other
sound
one,
was
I think
breaking
we're
up.
getting a lot more.
Nothing further.
Mr. Marsh?
Thank you, Your Honor. I would just ask the court to note that it does appear like the firearm at issue in this case was not found in Mr. Sandoval's car. It looks like it was found under a seat in somebody else's car that Mr. Sandoval wasn't even driving. I am hopeful, given the limited history we have of Mr. Sandoval, that he is well aware that he cannot be anywhere near firearms. It does seem like this might be a case where he was in somebody else's car. They kept a gun in there that he didn't know about. So if the court's inclined to impose a bond, we would request something lower that gives him a reasonable opportunity at release. Something in the range of $2,500 should give him enough skin in the game. Make sure he deals with this case.
Mr. Sandoval, I am going to impose a $5,000 cash or secured bond on this case. If you do post bond, you'll be released to pretrial services. You have to stay in contact with that agency. You're not allowed to possess or consume any alcohol or illegal drugs.
I got like 4
and
streams
you're
going,
not
so
allowed
make
to
sure you
have
hit
any firearms.
Pima
Do you
County.
understand all those conditions?
I got
Your next
Dade,
court date is going to be October 13th at 1:30
Maricopa,
in the afternoon. That's a
this one,
preliminary hearing.
and
That date may or may not occur, but
Pima.
you are expected to show up at all future
So make
hearings.
sure you
And
go to
if
the
you
live
fail
tab
to
to
appear,
choose the
they
correct
could
one.
issue a warrant for your arrest. Do you understand the consequences if you don't show up for court?
Yes, ma'am.
If you do get released, you also need to contact your federal probation officer
Ella, thank you
the
for
first
follow.
working day following release. Do you understand that as well?
Yes, ma'am.
We do have to talk about a warrant out of Sarita. It looks like there is a contributing to the delinquency of a minor and
that's
being in the
Awa right
park
there.
after hours. It happened in 2019, and we're still showing a warrant on that. I'm going to release you on that matter, sir, and give you a future court date. That court date is going to be October 28th at 8:30 in the morning. If you are still in custody, talk with your attorney so that they know
Regina, thank you
and
for that
maybe
heart.
they can assist you in getting that court date moved until you get released or figure it out. If you're out of custody, though, you do have to go to Sarita Municipal Court on October 28th at 8:30 so you can get this matter taken care of. It's not going to go away. Do you understand that, Mr. Sandoval?
Yes, ma'am.
And if you don't show up to court on that case, they could issue another warrant for you. Do you understand that as well?
Yes, I do.
All right, you're all done for
All right,
today.
Thank you.
The court address for those in downtown Phoenix will be on your paperwork. Bond is set in your case at $5,000. That is secured. If you deposit that with the court, you will be released. You have written conditions that you are ordered to comply with. You may not have any contact with the alleged victim. According to police, that person lives in Texas. You may not leave the state of Arizona. So needless to say, you can't return to the scene of the alleged crime because that is allegedly in Texas. You have other conditions of release. I'll let you go over for yourself, but those do include, as I said, you may not leave the state of Arizona without advance permission from the trial court, no drugs without a valid prescription, no driving without a valid license. Everything you need to know is on your paperwork. If you'll step to your left, you can get a copy of that and hand the officers the headphones. Thank you very much. All right, Mr. Montoya, Jose Montoya, will you get the headphones on and come into the podium, please?
Señor José Montoya, por favor, póngase los audífonos e ingrese a la sala al podio.
You guys can't see over here. Let me fix this up for you really quick, guys.
All right, sir. If you have any trouble hearing me, Well, let me say this. Can you hear the interpreter?
Can you guys see now? Is everybody good? Can you guys
Sure.
see? Let me know.
Yes.
All right. If you have any trouble hearing them, you might want to plug your other ear so that you can hear her better.
Can you guys hear her too? Can you guys hear
All right. Sir, may I have your full name and your date of birth?
And it looks like Polk County didn't happen today, so next time.
José Antonio Jacobo Montoya, 18 de abril de 1967.
¿Qué fecha?
18 de abril de 1967.
¿Qué?
José Antonio Jacobo Montoya, April 18th, 1967.
All right, thank you. You have been arrested on one allegation of failing to show a driver's license or other identification when driving a vehicle. That's a Class 2 misdemeanor. There is probable cause for it. I'm not appointing a lawyer for you, though, because I am going to release you, and we don't appoint lawyers in this kind of misdemeanor case unless you are given a bond.
That's wild.
So your next court date will be in 3 weeks. It is October 21st at 9 o'clock in the morning in the Peoria City Court. That address will be on your paperwork. As I said, I am releasing you on your own recognizance. You are ordered not to miss any court hearings. Do not possess any drugs without a valid prescription. Do not drive without a valid driver's license. Everything else will be on your paperwork. If you step to your left, the officers will give you a copy and you can give them the headphones. Thank you.
Look, put it. Look. You tell me what looks better. Do you prefer the way I had it or this way right here? Because this is the way the screen looks. What do you guys tell? Is it blurry now?
All right, if the interpreter could make a general call for service, if you didn't already. If you did, you can just tell me.
No, Your Honor, the interpreter is not. Would you like the interpreter to also ask those who may need the interpreter to raise their hands?
No, it's not blurry.
¿Hay alguien más que requiere los servicios de la intérprete? En caso que sí, por favor, levante la mano.
Is it still blurry?
Okay, we see no hands. Thank you so much, ma'am. Have a great day.
Thank you, Your Honor.
Bye-bye. All right, Mr. Jackson Burhell, Trevon Jackson Burhell, will you please come to the podium? After that, Andy Sustaita, will you please go to the chair? Good morning, sir. May I have your full name and your date of birth, please?
Trayvon Jackson Burhill, 2/28/1997.
All right, thank you. You're here on one new case and a probation hold. In the new case, you were arrested for allegations of possession of a weapon by a prohibited person, possession of narcotic drugs, and possession or use of a weapon during the commission of a drug offense. Those are all Class 4 felonies. Unlawful flight from a law enforcement vehicle, that is a Class 5 felony, and reckless driving, a Class 2 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for you in this case. I am also appointing a lawyer for you in your probation case. You are on probation for armed robbery, a Class 2 felony, and the probation department will be filing a petition to revoke your probation based on this new arrest. So you will have a lawyer in your probation case also. Right now, you have slightly different court dates in the cases. Eventually, they will come together in the system, and you should end up with the same lawyer for both cases. The first court date is going to be in the new case. That will be October 8th at 8:30 in the morning. I believe that's this coming Wednesday. That is a status conference in the new case only in the downtown Superior Court. Your preliminary hearing will be Friday, October 10th at 8:30 in the same court. In between those, on Thursday, October 9th at 8:30 in the morning, you will go to probation court for a revocation arraignment and possible disposition hearing. In the probation case, the court finds that you will, in all reasonable probability, be revoked to prison, and so you do not have bail at all in your probation case. You are held without bond. In the new case, you have a $40,000 secured appearance bond and written release condition. You should not bother trying to post that, though, if you are still being held without bond in your probation case. You can talk to your lawyer if you have any questions about how that works, but just because you have a bond in the one case does not change the no bond hold in the probation.
Hey, Rachel, thank you for that daily.
Everything will be on your paperwork. If you step to your left, the officers will give you a copy. Thank you. Mr. Sustaita, Andy, and then Mr. Goodlow McGarry, will you go to the chair?
That was going to go to prison. We give you too much work, Evan.
Hello, sir. May I have your full name and your date of birth, please?
Andy Sustaita, 5/15/78.
78?
Yeah.
Okay, we have 76, so I'm going to put that in here. I believe the other one will probably be entered as an AKA or an alternate date of birth.
I got 3 streams running, so I gotta keep up with everything.
But I will correct it in our system for today's purposes. All right, sir, you are here on 2 probation violation warrants. As you know, you are on intensive probation. And back on September 10th, so almost a month ago, supplemental petitions to revoke your probation were filed. That means you were already in probation violation proceedings, and then they accuse you of committing brand new violations after that petition to revoke had been filed. So these supplemental petitions allege that you committed violations of terms 3, 4, 5, and 15.
Oh, not 15.
All right. I'm going to give you a lawyer. It should be the same lawyer that you have for the already pending petitions. You need to go have a revocation arraignment hearing on both of these petitions, and that will be October 9th at 8:30 in the morning. That's 1 week from today. I don't know what other probation court hearings you may have already have had scheduled, but we are scheduling this one for October 9th at 8:30 in the morning. And pursuant to Rule 7.2C, the court finds that you will, in all likelihood, be revoked to prison in one or both of these cases, so you are held without bond in both of these cases. If you step to your left, you get a copy of your paperwork. Thank you. Mr. Goodlow McGarry. After that, Michael Dorn. Will you please go to the chair? Hello, sir. May I have your full name and your date of birth?
Sean Goodlow McGarry, May 2nd, 2005.
All right, thank you. You're here on a new case. You were arrested for allegations of discharging a firearm at a residential structure. That's a Class 2 felony. 2 allegations of aggravated assault with a deadly weapon. Those are Class 3 felonies. 2 allegations of endangerment. 1 of discharging a firearm in the city limits, and 1 allegation of disorderly conduct with a deadly weapon. All of those are Class 6 felonies, and 3 allegations of criminal damage as Class 1 misdemeanors. These are all alleged to have been committed September 27th of this year. There is probable cause for all of them. I am appointing a lawyer for you. Your next court date will be this coming Wednesday, October 8th at 8:30 in the morning. That is a status conference in the downtown Superior Court. Your preliminary hearing will be October 10th at 8:30 in the same court. Based on what's been alleged against you, the court finds that you pose an extreme risk to the alleged victims and a high probability of victim or witness intimidation or retaliation. There is a strong weight of evidence alleged against you, and if you are ultimately convicted in this case, which is a long time from now, but if you are convicted, many of these allegations are prison mandatory. So on this basis, the court sets bail in your case at $100,000. It is cash only. If you post it, you will be on an electronic ankle monitor on house arrest. Absolutely no contact with the alleged victims, whether you are in or out of jail, not through third parties, not through social media. Obviously, you cannot go to the scene of the alleged crimes. No weapons, no drugs, no alcohol. Everything else will be on your paperwork. If you step to your left, I'll give you a copy. Mr. Dorn, Michael Dorn. After that, Javante Cheatham, will you please go to the chair? Mr. Dorn, may I have your full name and your date of birth, please?
Michael Dorn, 12/24/78.
Thank you. You're here on 1 new case and 1 probation hold. In the new case, you were arrested for 2 allegations of possessing narcotic drugs for sale, 1 allegation of possessing dangerous drugs for sale. All of those are Class 2 felonies. 2 allegations of possession of narcotic drugs, 1 of possession of dangerous drugs. Those are all Class 4 felonies.
I only had one thing on me.
Talk to your lawyer about that. No, they allege you had 3 types of drugs. Also, using an electronic communications device to facilitate a drug transaction, also known as a wire charge. That is a Class 4 felony, and there is probable cause for it. I am appointing a lawyer to represent you. Your next court date is a status conference this Wednesday, October 8th at 8:30 in the morning, and a preliminary hearing will be October 10th at 8:30 in the same court. You are on probation for drug possession as a Class 4 felony, and the probation department will be filing a petition to revoke your probation based on this new arrest. So you will have a probation court date on Thursday, October 9th at 8:30 in the morning. That is scheduled as a revocation arraignment and possible disposition hearing. Oh, I apologize, officers. I need to reprint the probation one. I forgot to check any boxes. All right, just give me 1 second. Alrighty. Now, in the new case, based on your criminal history, what's been alleged, and the apparent large weight of evidence against you, as well as your potential access to illegitimate funds with which to post bail and flee the jurisdiction, bail is set in the amount of $75,000. That is cash only, dollar for dollar. In the probation case, that remains a Prop 200 case as of today, which means you are legally entitled to bail in it. The court sets bail in the probation case in the amount of $10,000. It is cash only. If you post these, you have written release conditions you're ordered to comply with in both cases. Those include calling your PO within 72 hours of any release. If you please step to your left, once we've got that reprinted, we will send it out.
So to be clear, I can have bail on both of those.
$85,000 cash only.
Okay.
Thank you. Mr. Cheatham?
You want to head up there?
85. That fool ain't going nowhere.
After that, I need Ramon Trujillo.
Ramon.
Where's Mr. Cheatham?
Come on down.
Hello, sir. May I have your full name and your date of birth?
Javante Cheatham, 4/7/2006.
All right. You are here on two matters. I'll start with the most straightforward. That's the new arrest. You have been accused of armed robbery, a Class 2 felony, also aggravated robbery, a Class 3 felony, 2 allegations of possession of a weapon by a prohibited person, those are Class 4 felonies, 1 allegation of possession of a prohibited weapon, that's a Class 4 felony, and resisting arrest passively, that's a Class 1 misdemeanor. There is probable cause for all of those. I am appointing a lawyer for you in this case. And I note, because this is important for considerations of sentencing and potential outcomes in your case, there are at least 2 alleged dates of crime in this case. Ms. Gaunt, did you want to appear in this case?
I did, Your Honor. Brooke Gahn on behalf of the state.
Brooke?
Okay, apologies. I just caught your camera view on my left. Alrighty. I'm gonna keep going, but then I won't forget to come to you before I rule. All right. So, Mr. Cheatham, there's probable cause for all of those, and I am appointing a lawyer for you. I'll give you your court dates in a moment. Now, you are on probation and in the juvenile transfer, it's the JTOP program, the program that's intended to keep adult convicted youth from continuing to commit crimes. Yes. So you're in that court. And there was already a warrant out for your arrest for failing to appear. Also, the probation department has filed a petition, they filed a term 1 hold, notifying you and the court they will be filing a petition to revoke your probation based on this new arrest. So at this moment in time, you're going to have court dates in 2 different courts in your probation court, because right now the JTOP judge has not booted you out of JTOP. Frankly, you should expect that, but that is up to that judge. It is not up to me. So at this moment on that warrant, which was a failure to appear warrant on October 1, 2025, and Judge Koval issued a warrant for your arrest. I'm going to give you a court date in his court, currently October 8th at 8:30 in the morning. He will see this, that you got arrested. His staff will see it. They may vacate this and just put you into warrant status and let you go, meaning probation violation status, and just let this matter proceed in probation court. It's up to Judge Koval, and I can't predict what he would do other than to say that in most instances, I believe they will not continue to see you in JTOP court. They will let this proceed in probation court. In the meantime, the probation department has filed this hold, notifying you and the court they're going to file a petition to revoke. So I'm also giving you a court date in probation court, which is the next day, October 9th at 8:30 in the morning. It's a probation revocation arraignment hearing. And that address is going to be on your paperwork. So I'm just going to let counsel know before I hear the state's recommendation on bail or release that this puts this status of still being in JTOP and now probation violation puts the court in a slightly difficult position in terms of what the court would normally do. And I'll let you know, Mr. Cheatham, in the absence of the JTOP warrant, I would be holding you without bail in the probation case. The court believes that you are very likely to be revoked to prison in that case and get some prison time in the new case if you are convicted. There does appear to be a strong weight of evidence against you in the new case with offenses committed on multiple dates. So with that allegation, the odds of you going to prison start getting very, very high, and the court would not normally allow a probationer to be out in the community when they are pending a likely revocation to prison. But so, Ms. Galt, what the court had been contemplating, and you can certainly comment on this, because It is not practically speaking possible for the court to issue a no bond order in a case and then in the same case set a bond. That is something that, procedurally speaking, I believe the sheriff's system cannot process. Now, so the court was inclined to go ahead and set bail in both and make that bail cumulative, because it is difficult to say, you know, what the charging decisions will be down the road, what Judge Kogel's decision will be, and so this court was intending to set appropriate bails for everything. And what I was inclined to do, and then you can comment on what you think I ought to do, is in the new case, and let me double check that I saw your recommendation. I did. I was contemplating 50,000 secured, then in the probation hold, 25,000 secured, and in the JTOP warrant, meaning if everything else goes away and all he has is the JTOP warrant, 5,000 secured, which would be 80,000 secured. So you can go ahead and comment on that if you want, please, Ms. Goff.
Thank you, Your Honor. The state had initially requested in the new case a $75,000 secured appearance bond along with electronic monitoring if Mr. Cheatham is able to post that. That was based on his significant juvenile record. He has prior juvenile adjudications for 5 felonies, and 4 of which are for minor in possession of a firearm and 2 are for attempted theft. He allegedly robbed the victim at gunpoint along with other armed accomplices. He is currently on probation for armed robbery. I believe that issue alone is really what gives the state most concern here, is that he is on probation for the same criminal conduct that he's before the court on today. When he fled from law enforcement, he was armed with a firearm with a Glock switch, which again increases his dangerousness in the community. So that's why we were requesting the $75,000 secured. In regards to the probation case, I certainly understand what the court is saying. The state had initially asked for him to be held non-bondable pursuant to Rule 7.2C. Again, because it's certainly the state's position that there is a reasonable probability that he will be sentenced to prison, given his continued engagement in this same type of very dangerous criminal conduct. But given what the court has indicated regarding the procedural status of that case, I think the court proceeding in the way that the court has outlined will likely achieve the same ends in terms of being able to safely protect the community. Thank you.
All right, thank you. And you do make a good point, and considering, you know, the other cases that the court sees, I'll tell you, Mr. Cheatham, I was not aware, I'm not sure why, but I think your juvenile history didn't come across as fully in what I was provided, that your juvenile history indicated that level of ongoing activity. And so it's, you know, the court is, I don't want to overweight the fact that you're young. But because the offense conduct that is presented is extremely serious, and so is your history. And the county attorney makes an excellent point about, we're talking about 2 dates of crime, 2 separate types of offenses alleged in the new case. One is the armed and aggravated robbery, as to which there is a substantial weight of evidence. Then there is the allegation that at apprehension, the running from the police and the Glock switch that they alleged was literally on your body. And the court believes that what you present is a level of dangerousness that's far beyond what an average person born in 2006 is generally presenting to the court. So I believe that the court's inclination was,
I wouldn't be surprised if they turned them over to the feds,
based on the idea that you're young and did not have the level of juvenile background and apparent fixation with weapons that your juvenile history and the current allegations and your current probation case strongly indicate. So the court believes you pose a real risk to people in the community, whether you are young and unassuming looking, that there's a lot of evidence to indicate it is risky to release you into the community.
This was done.
and the entirety of the non-participation in JTOP. All of that adds up to a picture that makes the court believe it is not safe to release you on anything less than a $75,000, hold on, I'll give you a chance to talk, a $75,000 secured appearance bond in the new robbery case, a $50,000 secured appearance bond in the probation violation, that's number 34 on the calendar, and I will keep the $5,000 on the JTOP FTA because that is strictly for being on probation for a serious felony and blowing off JTOP. Right now, I will give you a chance to speak, although because I will say that ups your bond to $130,000. I'm not going to at this. Well, I'd have to set it in all the cases, and he's on probation. You know what? I will order the ankle monitor in the new case only, and this is because the court believes that, pardon me, with a younger population, ankle monitors tends to have a more significant effect on controlling behavior. That being said, in your case, the court believes that that is not remotely sufficient to help protect the community against your potential danger and high risk of non-appearance. Now, you can speak, Mr. Cheatham. I've appointed a lawyer for you. You have the right to remain silent in all of these matters about what you're being accused of. Do you understand you have the right to remain silent?
Yes, ma'am.
And do you understand that this hearing is being audio and video recorded
and streamed on
and
TT
things that you might choose to say about what you've been accused of, which can be very tempting since two other people just did it. It can be tempting to want to respond. You are unable to respond without your statements possibly being used against you today or any later hearing, including your trial on what may be prison mandatory charges. Any new felony for you is potentially prison mandatory because you've had you're on probation already. So you are facing potentially life-changingly serious consequences. Your lawyer can tell your side of the story without it being held against you, but your lawyer's not here today. So I always recommend that whatever defendants want to say, they confine it to what conditions of bail or release the court ought to set rather than talking about what you've been accused of. Because if you want to tell me your side of the story in an attempt to get me to lower the bail by saying things that may literally get you put in prison, then you are not understanding the nature of the right to remain silent, and you're making a bad decision. If you're trying to get a better bail on this by saying things that could be used against you, that is not a good idea. So do you understand that warning I just gave you?
Yes.
Do you want to say anything about what conditions of bail or release I should set?
I was just gonna say something about the JTOP warrant.
Mm-hmm, go ahead.
I never knew I had a JTOP warrant. My phone was like off for like 2 weeks, and then when my phone got turned back on, I guess my probation officer told me that I had a warrant out for my arrest. They told me that they sent mail through the mail and stuff, but I had never got it for.
No way at that age you're gonna have your phone off.
All right, well, talk to your lawyer about that. It looks like that they reset it at least twice, and that Judge Koval was had a chance to listen. No, this says, I'm sorry, July 16th. You were present, and they set a court appearance for yesterday at 10:30 in the morning, and the warrant that went out was indeed yesterday. And your arrest time, well, the police allege they arrested you around 6 p.m. yesterday. So you were physically present in court when your court date that was yesterday morning was given. You were arrested till yesterday evening. So you straight up failed to appear. I can see it in the docket. So talk to your lawyer about that. Frankly, Mr. Cheatham, that is the least of your concerns right now. So talk to your lawyer about that. You're going to end up with the same lawyer for everything. And you can talk to your lawyer about everything that just happened today. Did the state have a motion on the new case? Is that also why you're here?
Yes, Your Honor. The state would move to seal the Form 4. I think there's two versions, the original and then a superseded. We would request to redact both of those, or excuse me, to seal both of those and replace them with the redacted versions. They include the victim's name for the new case. Additionally, the case that he is currently on probation for, there was a minor co-defendant whose name and date of birth was listed in those as well.
Okay. All right. So that motion is granted. I've re-signed it. Let me make sure my staff re-closes it so that it takes. And so, Mr. Cheatham, that's just because the police have included some information in the booking paperwork that is not supposed to go into the public record per court rules. And so the state is supplying a redacted copy, meaning that stuff will just be whited out. And then, but you and your lawyer will have access to discovery in the normal case process. This just has to do with what goes up on into the public record right now. So talk to your lawyer about that, but we don't deny those motions, that this is well taken. I'm glad they're making it. I grant it, but you can talk to your lawyer about that. Everything's going to be on your paperwork. And did you want to be excused for now or stick around, Ms. Gaunt?
I'll just stay, Your Honor, until the matter with counsel. Thank you.
Okay, sounds good. Thank you. All right. So, Mr. Cheatham, if you'll step to your left, we're going to give you paperwork for everything. Thank you. Mr. Trujillo, Ramon Trujillo, and then Destiny Mestas, will you please go to the chair? Hello, sir. May I have your full name and your date of birth?
Ramon Trujillo III, 6286.
Okay, it sounded like you said Trujillo. Did you say Trujillo?
Yes, ma'am.
Okay, thank you. You're here on a total of 3 things. One is a new felony arrest, one is a probation hold, and one is a traffic misdemeanor warrant. So I'm going to start with the new case. You've been booked in for theft of a means of transportation, a Class 3 felony, dangerous and narcotic drug possession. Those are Class 4 felonies. There is probable cause for all of those, and I am appointing a lawyer for you in this case and in your probation case. The probation department will be filing a petition to revoke your probation based on this new arrest. So you have to go to probation court as well. Your court date in probation court is October 9th, 1 week from today, 8:30 in the morning. In the new case, your court dates are, I'm not sure if I just said this, a status conference October 8th at 8:30 and a preliminary hearing October 10th at 8:30. So all of those are next week. In the new case, your bond is $5,000 secured. In the probation case, it is $1,000 secured for $3,500 total. Now, you're also here on a warrant from the South Mountain Justice Court for failing to appear in a driving on suspended license case. It's a Class 1 misdemeanor. Your court date there is going to be October 6th, which I think is Monday. Yes, Monday the 6th at 8:30 in the morning. That address is on your paperwork, and your bond in that case is $500 secured. That's the driving unsuspended. And I did appoint a lawyer for you just in the event you're not able to post bail. Then you will have a public defender at that hearing to help you on the bail issue only. We do not otherwise appoint lawyers in driving unsuspended cases. Everything's on your paperwork. If you step to your left, he's going to give you a copy. Ms. Mestaz? And then do you guys want to give counsel the high sign? He looks done, I just realized. I was waiting for him to come out, but I think his client is sleeping in there.
He's waiting for you, Your Honor.
Okay. Yeah. All right. So Ms. Mestaz and then Samantha Lopez. Yeah, and I want to do Mestaz first, please. Yeah. I didn't realize she was napping back there. All right. Hi, ma'am. Can I have your full name and your date of birth?
Destiny calling Mestas. My date of birth is August 30th, 1994.
Okay, thanks. And just for the DOs, you can leave Lopez in there or have her sit down. It's up to you guys. Okay, it's up to you guys. All right, Ms. Mestaz, yes. You're here on a new case. You were arrested for theft, attempted theft of a means of transportation. It's a Class 4 felony. I am appointing a lawyer for you. Your next court date will be a status
I said I was
conference.
going to represent myself because...
Okay, and that is your right. But that is a very formal waiver of rights that we do not do in this court. So what we do is, I appoint a public defender for you. If that's what you want to do, your lawyer will literally help you waive counsel. But it has to be done in writing. There's a huge advisement. That is absolutely possible, just not today. So I'm going to give you a lawyer who will literally help you do that if that's what you want to do. So that's the reason I'm appointing a lawyer. It's not negotiable. I'm doing it anyway. But if you want to waive counsel, you could do it at a later hearing. All right, your later hearings are going to be a status conference October 8th at 8:30, preliminary hearing October 10th at 8:30. Those will be in the downtown Superior Court.
Okay.
Bond is set in your case at $5,000. It is secured. If you bond out, comply with all of your written conditions. That includes, do not go to the scene of the alleged crime, no contact with the alleged victim. You may not leave the state of Arizona without the advance written permission of the trial court. I am not giving you that permission. Absolutely no weapons, no drugs without a valid prescription. If you please step to your left, I'll give you a copy of your paper.
Could I speak, please?
Sure.
Okay, So I'm going to be detained, correct?
I gave you a bond. If you post it, then you are released.
Okay, but until further notice, I will be housed inside the county jail.
I'm sorry, speak up.
I said, but until further notice, I will be housed inside the county
Until
jail.
you post a bond, yes, you will go to the,
Okay.
I'm sure you'll go to the Estrella jail.
Okay, but this was just a civil dispute. I mean, there wasn't burglary or nothing. I didn't break into this car or anything.
All right, the police have absolutely made probable cause for attempted theft of a means of transportation. So you can speak to your lawyer about that or do your own research on it. But the case is going forward and you'll have to post bail.
So my lawyer is going to be from California.
Okay, well, talk to them. It'll all happen down the road. All right, step to your left now, you can take your paperwork. All right, Ms. Lopez? And then Ricardo Trujillo, we go to the sheriff.
Oh, this is a lawyer. Somebody got a lawyer.
All right. All right, ma'am, may I have your full name and your date of birth?
Samantha Natasha Lopez, 9893.
All right, and then the appearance of the state, please.
Thank you, Your Honor. Brooke Gahn on behalf of the state.
And defense.
Good morning, Your Honor. Dominic Cleese with Law Office of DM Cantor on behalf of Samantha Lopez.
Thank you. Can you tell me your last name again? I'm not sure I saw it on the NOA.
Yes, Your Honor. Cleese, it's Callelse.
Okay, thank you. Just want to get it right. Okay, so Ms. Lopez, you have been arrested. In a new case, the allegations are aggravated driving under the influence of alcohol or drugs on a suspended license while impaired to the slightest degree. That's a class 4 felony. Also, aggravated driving under the influence of alcohol or drugs by a third or subsequent DUI. That's a class 4 felony. And possession of dangerous drugs as a class 4 felony. All right, before I make any probable cause finding, did the defense want to be heard on probable cause?
Yes, Your Honor. Thank you, Your Honor. Regarding the second count, the third DUI within 84 months, it appears based on the probable cause statement that there is no second DUI conviction. It looks like Ms. Lopez was arrested and charged on September 26th of this year, but that is a current pending charge. So for that reason, I would ask that the court not find probable cause with respect to the second count, as this is not a third offense within 84 months. Regarding the third count, the dangerous drug possession, it does not appear that the officer did a preliminary or field test to confirm whether or not this was in fact methamphetamine, and so for those reasons, I would ask that the court not find probable cause for that as well.
All right, thank you. Ms. Gaunt.
Thank you, Your Honor. I think defense counsel is correct. I don't believe that there is a third DUI conviction. There is certainly a third arrest, but not a conviction. Additionally, although I do think they indicated that they believed that it was methamphetamine, I don't believe that there was either an admission or a field test. So I don't think there's probable cause on that charge as well, Your Honor.
Okay, thank you. Ms. Lopez, I agree with the lawyers that there's not probable cause on a third or subsequent DUI. There may be at some future point, but there's not today. And there is not, for purposes of this hearing only, probable cause for the dangerous drug possession. Neither of those is dismissed. I'm just ignoring them for purposes of release conditions. And you can talk to your lawyer about how that works. But right now, I'm not appointing a lawyer for you. You didn't do the financial paperwork. I did note Mr. Kalisis was a limited NOA, but your client did not do the financial affidavit. So, ma'am, I'm not appointing a lawyer for you in the event that you don't hire your own. You could fill out financial paperwork at a future hearing. It's an affidavit, and the court might appoint counsel for you then. I'm just not doing that today. Okay. All right. So I've got court dates coming up. Don't let me forget to give those to you. I sometimes forget when there's a lot of discussion. So before I set conditions of bail or release, what's the state's recommendation?
Thank you, Your Honor. The state is asking for a $10,000 secured appearance bond, and if Ms. Lopez is able to post that, we'd ask for pretrial services with alcohol and drug testing and monitoring, along with a judicial prohibition against operating a motor vehicle. The state is concerned that Ms. Lopez is an alleged repetitive impaired driver. As we have already referenced, she was arrested on September 26th, which was less than a week ago, for allegedly being impaired while she was driving. In that incident, she collided with a city vehicle. And it's unclear from the Form 4 whether she again was in a collision last night while she was driving, impaired, allegedly impaired. The Form 4 it seems to indicate there was front end damage to her vehicle, but that certainly could have been from the accident she had on the 26th. We are concerned that she is a significant danger to the community, given what appears to be some repetitive impaired driving behavior, and that she continues to drive, whether impaired or not, while she is legally prohibited from doing so, given the fact that her license is suspended. Given all of that, Your Honor, we think that that bond is appropriate to secure the safety of the community. Thank you.
All right, thank you. Mr. Calise.
Yes, thank you, Your Honor. So first, I want to start with the fact that I do not believe Ms. Lopez is a flight risk. She has no prior failure to appears. She lives in Arizona with her 1-year-old son. She is the primary caretaker of her son. She has no prior felony convictions. She does have the prior misdemeanor DUI conviction, and then the other current pending misdemeanor DUI offense. The damage from the vehicle that the officers observed, my understanding is that's the basis for conducting the traffic stop. The damage was extensive, but that damage was the result from the previous case, the first misdemeanor DUI involving the collision with that vehicle. There was not another accident in the DUI offense that led to her arrest in this case. Ms. Lopez does suffer from drug addiction, and she intends to check into a rehabilitation program once released from this hearing, Judge. So she would ask to be released to pretrial services so that she can, with drug testing, so that she can go to a rehabilitation program, which is really the root of the cause here, Judge.
All right, thank you. Ms. Lopez, I've considered what's been alleged against you, and I do note, counsel, pretrial is showing 2 prior felony convictions out of Florida. So if your client told you differently, that bears investigation.
I got another stream
This
running.
is listed as 2016 grand theft and 2015 grand theft. And Ms. Lopez also has a lengthy criminal history out of California, but like many California criminal histories, California does not spend a lot of time entering dispositions in cases. And so I'm assigning it the weight that I would give it. I'm not assuming they're convictions, but it is very long. It is multiple pages of arrests going back to 2010 out of California. So I've considered that, and ma'am, I've considered the apparent risk that you pose to the community and your apparent inability or unwillingness to comply with court orders like administrative suspensions of your license. The court is very concerned that you pose a risk to people in the community. Bail is set in your case in the amount of $5,000. It is secured. That means you can use a bail bondsman. If you post it, you will drug and alcohol test for the court. The court is including alcohol because what is alleged, which is, again, that literally doing this 5 days after the other allegations supposedly occurred. I agree with the state. It was unclear whether the damage that they say, the heavy front end damage they allege they saw to your vehicle yesterday was from a collision a week ago or from a collision yesterday. But the court is very concerned that people who repetitively commit this type of offense tend to hurt and kill other people with their cars. So you are categorically prohibited from driving without the further order of the court in this case. That means even if you got your license back tomorrow, you may not drive. You need to get a court order for that. In this case, alcohol and drug testing is mandatory. Pretrial is not allowed to remove that on their own. They have to get the court to do it. No weapons. As far as this court believes, you are a convicted felon. No drugs without a valid prescription. No alcohol, and again, this is 2 places in your paperwork. You may not drive any motor vehicle at any time. All right, anything else from the state?
No, Your Honor, thank you.
Defense.
No, Your Honor, thank you.
Okay, we're going to get that printed up for you, ma'am, and so I have lots of people left. If you want to keep using the room and it's okay with the DOs, you're welcome to.
Perfect, thank you.
Thank you. All right. Okay, are you sticking around with us? Yes, you can. Thank you. Have a good day. All right, we're going to go on to Ricardo Trujillo, please, and then Nicholas Baker, if you go to the chair. And I didn't give the dates, by the way. They'll be on the paperwork, but they are the 8th and the 10th. I did that thing. All righty, Mr. Trujillo, can I have your full name and date of birth?
Ricardo Valentino Trujillo, 10-10-88.
Okay, thanks. You're here on a new case. You were arrested for possessing narcotic drugs, a class 4 felony, and unlawful use of a means of transportation as a passenger. It's a class 6 felony. There is probable cause for both of those, and I am appointing a lawyer to represent you. Your status conference will be this Wednesday, October 8th at 8:30 in the morning, with a preliminary hearing October 10th at 8:30. Those will be in the downtown Superior Court. Based on your criminal history, bond is set at $2,500. It is secured. If you bond out, comply with all of your written conditions. That includes no contact with the alleged victim. That's whoever owns the allegedly stolen car. No contact with your co-defendant, who appears to be your brother. And obviously, no drugs without a valid prescription. If you step to your left, you get a copy of your paperwork. Mr. Baker. And then Amy Short, will you go to the chair, please?
Amy.
Hello, sir. Can I have your full name and your date of birth?
Nicholas Baker, 7/22/99.
All right, thank you. You're here on two things. One's a new felony case, and one is a traffic misdemeanor warrant. I'm going to start with the new case. You were booked in on allegations of possessing narcotic drugs for sale, a Class 2 felony, possession of narcotic drugs, and possession or use of a weapon during the commission of a drug trafficking crime. Those are both Class 4 felonies. Also possession of drug paraphernalia, which is a Class 6 felony. There is probable cause for all of those, and I am appointing a lawyer for you. Your next court date is a status conference, October 8th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be October 10th at 8:30 in the same court. Your bond in this case is $2,500. It is secured. That means you can use a bail bondsman. If you bond out, comply with all of your written conditions. That includes no weapons, no drugs without a valid prescription. You're also here on a warrant out of the Ironwood Justice Court in a criminal speeding case. It's a Class 3 misdemeanor, and you failed to appear last October in this case, and a warrant went out for your arrest. So your arraignment hearing is going to be October 6th, which is Monday, 8:30 in the morning in the Ironwood Justice Court. In this case, in the absence of the felony case, I might have given you a do-over, so I'm just going to set what's called a placeholder bond. It's $50 secured. That's on the traffic case. That's in case you don't post bond in the felony case. If you don't post bond, then when you get to Justice Court, you'll have a public defender there just to help you with the bond issue only. We don't otherwise give people lawyers in criminal speeding cases. You do have a lawyer in the felony case, though. So your total bond is $2,550. Everything is on your paperwork.
Okay. How could I get a bail bond or whatever? I don't have.
They take calls from the jail, so the officers can show you where the phone numbers are. You can call them from the jail.
All right.
All right. Thank you, Ms. Short, Amy Short. And then Jaquel Dillard, will you please go to the chair? Hello, ma'am. May I have your full name and your date of birth, please?
Amy Short, in 22779.
All right, thank you. You're here on two warrants, one in a felony probation case, one in a justice court case. Starting with the felony warrant, you are on probation for a Class 3 felony. Back on January 20th of 2023, there was a petition to revoke your probation filed. It alleges that you violated terms 6, 7, and 22. You'll get a copy of that from your lawyer. I am appointing a lawyer for you. Your next court date in the probation court will be 1 week from today, which is October 9th at 8:30 in the morning in the downtown Superior Court. That is a revocation, arraignment, and possible disposition hearing. The court address will be on your paperwork. You're also here on a warrant from the Encanto Justice Court in a case in which you've been charged with possession of an aggressive dog or an aggressive dog violation. That is a misdemeanor. And this warrant was issued out of the Encanto Justice Court on October 25th of 2022 after you failed to appear at a hearing in that case. And, I forgot to check boxes on this one too. Officers, I'm sorry, I need to reprint the Justice Court case for Ms. Short. All right, ma'am, I just forgot to check any release conditions. Let's see, okay. In the probation case, your bond is $2,500 secured. In the Justice Court case, it is $500 secured. That is $3,000 total, and you're going to have written release conditions in both cases. They will be the same. No weapons, no drugs, no alcohol. Call your PO within 72 hours. The main number is on your paperwork. If you don't post bond, you don't have to call. If you do post bond, call within 72 hours of hitting the street. Everything's going to be on your paperwork. We just need to reprint the Justice Court paperwork, and we'll send it out to you. Thank you. And Mr. Dillard? After that, Martell Johnson, will you go to the chair? Hello, sir. Can I have your full name and your date of birth?
Jaquel Dillard, February 5th, 1996.
Okay, thanks. You're in one new case and 3 probation holds. In the new case, you're arrested for possessing dangerous and narcotic drugs. Those are Class 4 felonies. There is probable cause for those, and I am appointing a lawyer to represent you. Your next court date will be a status conference in the downtown Superior Court this coming Wednesday, October 8th at 8:30 in the morning, with a preliminary hearing Friday, October 10th at 8:30. The probation department has notified the court they will be filing petitions to revoke your probation in all 3 of your probation cases. So you have to go to probation court for those. I am appointing a lawyer for you, and your court date for all 3 cases will be 1 week from today, which is October 9th at 8:30 in the downtown probation court. That will be a revocation, arraignment, and possible disposition hearing. In the new case, your bond is $1,000 secured. In each of the probation cases, it is $500 secured. That is $2,500 total. If you bond out, comply with all of your conditions, and call your PO within 72 hours. They have your paperwork for you. Thank you. Mr. Johnson, and then Ashley Young, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Martel Anthony Johnson, 090593.
Okay. I know it's cold, but can you take your hands out of your pants?
Yeah.
Okay, right. That's one that
Sorry,
is
I
a
know.
little weird on video.
Yeah.
All righty, sir. You're here on a new case and a probation hold. In your new case, you were arrested for narcotic drug possession, Class 4 felony, and drug paraphernalia possession, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. You're also here on a probation hold. The probation department will be filing a petition to revoke your probation based on this new arrest. So you're going to have slightly different court dates right now. Eventually, they will come together in the system. In the new case, your first court date is Wednesday, October 8th at 8:30. That's a status conference. Friday, October 10th at 8:30 will be your preliminary hearing. You'll go in between to probation court on October 9th at 8:30 in the morning for a revocation, arraignment, and possible disposition hearing. In the probation case, your bond is $500 secured. In the new case, can you get your hands out of your pants? Sorry. It's $50 secured, $550 with release conditions that will be on your paperwork. I'll let you step to your left.
$550.
$550, yes.
Secure what that means.
It means you can use a bail bondsman. All right, thanks. All right, Ms. Young, Ashley Young, and then Christopher Reichel, will you go to the chair? Hi, ma'am. Can I have your full name and your date of birth, please?
Ashley Young, 12/26/86.
Okay, thanks. You are here on a warrant in a pending felony case and a warrant from a justice court. I'm going to start with the felony case, and this is actually a newly charged case, not that new, that actually dates back to January. So there's been a criminal complaint filed against you, charging you with possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony, back on January 8th of 2025, somewhere in Avondale. This comes from the Avondale Police Department. But you will get a copy of the charges and police reports from your lawyer. I am appointing a lawyer for you. In the traffic case, that's out of the West McDowell Justice Court, it is a DUI. You've already been convicted, a drug DUI. Class 1 misdemeanor from 2021. And in this case, the warrant went out September 9th of this year, and it is a failure to pay fines and fees or a failure to do things like usually it's drug education or testing or something. So they issued a warrant for you. Now, I have a question for you, which is, did you get bond in your other cases? I know you came in, Glendale probably has a hold on you, and you've got a West McDowell case. I didn't have time to look it up. And I'll tell you why in a second, but I'll literally take your word for it, because if you lie to me, you only hurt yourself. So
No.
did you get bond, or are you processing for release?
No, I received a bond from Glendale.
Did you post it?
No, because I was waiting to see what happened here, so that way it could be done all
Okay,
at
do you
once.
think you're going to be able to post bond in Glendale and West McDowell? Are you going to be able to? You think if I release you, which I'm willing to do, which is why if you don't end up released, you're going to catch a warrant in both of these cases, which is why I'm saying you're only hurting yourself.
Right.
I'm willing to release you because the felony case is not new. We just didn't have an address for you. You haven't missed any court dates in the felony case. And the misdemeanor case is post-conviction, and it's not a failure to appear either. So I'm willing to release you, but I will not do you any favors if you don't actually end up released. So do you know what your total is?
It's 400 right now.
Do you think you're going to be able to post it if I release you?
I'm going to try to.
All right,
I was going to
just so you
wait.
know.
Yeah, I was going to wait till Monday because my next court date for Glendale is Monday, and then depending on
See if you
how
can
it's
get
going
out
to go,
of it.
I was going to try to get out. Yeah.
And so that's why I leave folks in your situation sort of to the end of the bonds, because I'm willing to release you, and like I say, because you only hurt yourself if you lie.
Right.
So I'm going to change it to release. That's why I didn't give you court dates yet. And so just know that if things go bad and you don't end up getting out, when my court dates roll around, there's gonna be a warrant issued for
Yeah.
your arrest, even though you're sitting in sheriff's
jail.
custody. That sounds crazy, but that is how it works. So I'm releasing you, which means they will not take you to court, no matter how
Mhm.
much you beg, because you are released.
Released, right.
All right. So in the new felony case, your court dates are going to be, we need to reprint, officers, October 16th at 8:30. So it's not for 2 weeks.
Okay.
Preliminary hearing October 20th at 8:30. I'm releasing you on your own recognizance because you just don't have that much or that type of criminal history. You're not without criminal history. I'm seeing 2 priors, they're drugs.
Mhm.
So I probably would have just been willing to give you a chance anyway, because this is, again, drugs, and your
Right.
priors are drugs. So just know that if you miss a court date and you were out of custody, nobody's going to give you a second try. We're just
Right.
going to give you a bond. So go to court. It's the 16th and the 20th. It'll be on your paperwork for downtown Phoenix. That's the new felony.
Okay.
Then in the DUI, your justice court, did you reprint it yet? Okay, I gotta take off the DU, I'm sorry, I gotta take off the lawyer on West McDowell. Will you, read one more time? Okay. So the justice court case, I'm not giving you a lawyer because you've already been convicted. You
Yeah.
only get a lawyer if you get a bond. I'm not giving you a bond. So I'm releasing you in West McDowell. That's gonna bump your court date out to the 14th of October at 1:30. So you do have a lot of time to make your way out of jail
Right.
before these happen. Don't lose this paperwork.
Mhm.
You know, if you lose it, you got a bad problem. You could
Yeah.
always call the court and say, when's my court date? I'm not under any illusions that you're likely to do that. So don't lose the paperwork. Everything's on there. I hope you show up. If you don't, there won't be any sympathy, and we'll be able to see when you got released. You can't go, oh, I was in jail. We'll look it up.
Mhm.
Glendale has their own city jail. If they hold you there, you got a different problem. We
Yeah.
won't be able to verify it, and we won't take your word. So just go, okay? Everything's on your paperwork. The steps you left, we give you a copy. Good luck next week. If all
Yeah.
goes well, you should be out in time for me.
Yeah.
All right,
Thank you.
sounds good. Mr. Reichel? And then Scott Humphrey, will you go to the chair?
Hey, Reina, thank you for the.
Hi, sir. Can I have your full name and your date of birth?
Christopher Reichel, September 19th, 1989.
Okay, thanks. You're on a new case. You were arrested for domestic violence, assault, disorderly conduct, criminal damage, and preventing the use of a telephone during an emergency. The first 3 are Class 1 misdemeanors. The telephone count is a Class 2 misdemeanor. There is probable cause for all of those. I'm not appointing a lawyer for you, sorry. Your arraignment hearing is going to be October 21st at 9 in the morning. If you want to try to qualify for court-appointed counsel, you have to fill out paperwork at Peoria City Court. They may or may not do it. That is their decision. I'm releasing you on your own recognizance with no victim contact orders. From the way the police gave me the probable cause, it appears the alleged victim does not live at that location. They didn't say whether you did or you didn't, but she appears not to live at that location. So I'm not ordering you not to go back there.
Mhm.
Sounds like it's your common parent's
Yes.
house.
Yes.
Are you living there?
Yes.
So I'm not prohibiting you from doing that unless your parents kick you out and then you got a different problem.
Yeah.
That's between you and your parents.
Mhm.
They're not victims in the case. So if your sister comes over and your parents tell you to leave so she can come over, you got to do it, because if you stick
Yes,
around and
I
she
under-
shows up
yep.
and the police get called, you get arrested.
I understand.
So absolutely no contact with your sister, even if she shows up at the place you live, because I cannot, nor would I, order her not to go to her parents' house. She's the alleged victim in this case. So she's under no court order to stay away from you. You're under a court order to stay away from her, which is enforceable by criminal statute. So it's a criminal case. Don't monkey with it. It's not an order of protection. It's a criminal release order. There will be consequences if you get arrested for violating it. No weapons, no drugs, no alcohol. They accuse you, and there appears to be some evidence of being an alcoholic. I'm not going to make you alcohol test. I can't do that in the city court. I'm saying
I understand,
you're
Your Honor.
prohibited from drinking. No weapons or drugs without a valid prescription. If you get served with an order of protection, then you have to comply with that as well. Only if somebody serves it on you. And that would be anybody. Like if your parents were to serve one on you, you're stuck complying with that. Anyway, everything's on your paperwork, but based on your criminal history, I'm willing to release you. I'm not seeing a pattern of this, and I'm not seeing, I see a DUI, I see drug paraphernalia, and an FTA. So I'm not seeing, I see an old, by the way, everything sticks around. 2009, you were arrested for criminal damage, domestic violence, but it got dismissed. So I'm just saying, we get granular detail on some of these criminal histories. So I'm releasing you. Don't monkey with release conditions. Everything's on your paperwork. Don't miss your court hearing.
Yes,
All right.
and I'll have to do my research, but are those charges that she can still drop
No,
technically?
no, she's not up to her. So, and by the way, witness tampering is a felony. Attempting to influence a witness's testimony is a felony. Committing one act in violation of my no contact order is aggravated harassment, a felony.
Understood.
I put the statute in your paperwork. Google that or aggravated harassment statute. You could send her one text, and if the police booked you in and the court found that that text was harassment, that is
Understood.
a felony. So serious consequences. Your court date is not for 3 weeks, October 21 at 9 in the morning. I believe you should be able to comply with these release conditions without a lot of effort. If you prove us wrong, you'll find out what happens, whatever that is. So it sounds like you understand it, and you'll comply. Yes?
Yes, ma'am.
Great. Then you are released. It still takes many hours to be released. Try to be patient. That's just part of the joy. But you should be out hopefully by dinner time tonight. All right,
Okay. Thank you, Your Honor.
all right, Mr. Humphrey. After that, Elvis Klein. We go to the chair, please.
Hey guys, just gonna give you guys a heads up. I'm gonna be getting off in the next few minutes.
Hello,
If you
sir.
guys
May I
wanna
have your
continue
full name and your
watching,
date
I
of
am gonna
birth?
leave the stream
Scott
up
Humphrey,
running on
March
YT.
17th,
If you wanna
2003.
go
All
ahead
right,
and check
thank
it
you.
out,
You were
Acting
arrested
Like
for
Alpha
reckless
on
driving,
YT,
class
if
2
you will.
misdemeanor. There is probable cause for that, and I am appointing a lawyer. No, I'm not. Sorry. I just say that so routinely. I'm not appointing a lawyer for you. We don't in this type of traffic misdemeanor unless you get a bond. I'm not planning to give you a bond today. I thought about it, and I will say that what they allege against you, as I noted in my order, appears to be particularly egregious and very deliberate. And it's the kind of behavior that the rest of the people on the road wish there was a cop around to see when somebody does it, because splitting traffic, cutting tightly in and out between cars on a motorcycle, startles drivers and can cause people to die. And, you know, the recklessness that they allege against you could easily be charged as aggressive driving, which is a class 1 misdemeanor, more penalties. The state could still do that. But we do not set bail based on how much we dislike what a person is accused of. We set it based on objective considerations of whether we think they're likely to appear,
If you will.
whether we think they're likely to commit new crimes, whether we think they're likely to comply with other release conditions. You don't appear, the police did not tell me that you have any other criminal history. I don't get it separately in a misdemeanor case. The police have to do it. They didn't say that you ever even been arrested before. So I'm going to presume that you have not, and that you don't like being arrested, and that they very likely impounded your vehicle for at least a month, which would tend to reduce the likelihood that you might commit this type of crime while you are pending this case. I will tell you that this exact type of driving behavior, if someone is hurt, could get you charged with aggravated assault. If someone is killed, could get you charged with second-degree murder by gross recklessness and extreme indifference to human life. So, with that lecture, and hoping that the overnight in jail was very unpleasant, such that you wish to avoid that in the future, I'm going to release you on your own recognizance to go to court October 22nd at 9 in the morning. I considered also ordering you not to drive. I have not done that because, again, we don't set bail based on how much we might dislike what someone is accused of, and how many times we might sign warrants and do these hearings for people who do get accused of murder based on speed alone.
Is this better? I just raised up my
Mr. Humphrey, will you
25%.
comply with these
Can you
conditions
guys hear me
and come
better
to
now?
court?
Is it the same?
All right, then you are released. It still takes many hours to be
Or
released.
is 50%
Try to be
better?
patient. If you step to your left, he will give you your paperwork.
So this is
Thank you.
50%. 50% or 25%?
Klein?
What's better? This is 50 right now.
And then Sabrina Sedana, will you go to the chair? Hello, sir. Can I have your full name and your date of birth?
Elvis Christian Klein, and it's 5799.
Okay, thanks. You're here on a warrant from University Lakes Justice Court in a criminal trespassing case. It's a class 2 misdemeanor. This is a failure to appear warrant, and your arraignment hearing is going to be October 21st at 1:30 in the afternoon. That's about 3 weeks from now. I'm going to release you on your own recognizance because I looked at the court record and I saw that you've been to court at least a couple times. This is your first warrant, and it is criminal trespassing, which is on the continuum of offenses, less dangerous. So it's your first warrant. I am going to give you a do-over. Don't blow it, because then you'll come back and somebody will see that you came through jail,
really quick. I want to check
you
my
got a
microphone.
do-over, and you blew it off. Don't blow it off. Show up. I know you know how to call them because their court record says you called them before. So if you have trouble getting there, call and ask for a different court date. They'll usually do it if you do it before the warrant goes out. So give them a call if you can't make it. You got 3 weeks to get there. Will you do that?
Yes,
All
ma'am.
right, also stay away from wherever this was.
Okay, wait, so, am I still trespassed from ASU?
That, I'm ordering you not to return to the scene of the alleged crime. If that was ASU, then yeah. But I'm not they trespass you. The ASU can say you are disinvited from ever setting foot on our property. They do that. What I do in the criminal case is I prohibit you from going to the scene of the alleged crime. Sometimes I know that might be the entirety of the ASU campus, sometimes I don't. It's also true to say that I don't know when somebody might be a student and when somebody might not. But if you've been trespassed from ASU, they don't forget.
Yeah,
so you're going to get arrested. You could also be booked in for the misdemeanor of violating this order. So all I can tell you is, if you believe you have a legal right to be there, that is between you and ASU, because they can trespass people who are full-time, fully paid students. They can trespass them. So that's a civil issue right now. They haven't, I'm not being asked to find probable cause because this is an old case. Probable cause is already found. This is just a warrant. If you go there again and then they book you for it, I would have to find probable cause, but this is a pending case. So I don't even know what you did, except now you've sort of told me. So, or allegedly did, sorry. I'm releasing you. Go to court. That's the main thing. Stay away from wherever this was. Everything's on your paperwork. You'll be out in a few hours. Be patient. If you step to your left, you get that paperwork.
All right.
Thank you.
Guys.
Have a good day.
Good luck.
So I'm gonna get going, but
and then
guys,
Robert
like I said, if you
Bender,
guys want to continue watching, jump on over to YT. I'm gonna leave the stream running. All right. I do
Hello, ma'am. Can I have your full name and your date of birth?
Sabrina Marie Moreno Saldana, 252,000.
Okay, thanks. You are before the court on a total of 3 things. One's a new arrest, 2 are probation holds. In the new case, you were booked in for possessing narcotic and dangerous drugs. Those are class 4 felonies. And the probation department has notified the court that they plan to file petitions to revoke your probation in both of your cases. Looks like you're on probation for 1 felony and 1 misdemeanor. So I'm going to give you a lawyer in all of the cases, and I'm going to give you some court dates. The first one is going to be October 9th, which is 1 week from today. That's the probation court date at 8:30 in the morning. It's on your paperwork. It's in the downtown Superior Court. Then the week after that, you're going to go for the new case on October 16th. That's a status conference, 8:30 in the morning. Preliminary hearing, October 20th at 8:30. So you don't have any other conditions in this case. I did check the box to give you the probation phone number because your terms and conditions require that you call your PO within 72 hours of any release from any jail. So don't forget to do that. I didn't find probable cause for the drugs, though, for purposes of this hearing only. So you're entitled to be released with no other conditions. You don't have bond. I'm not ordering you to do anything. I'm reminding you to call your PO, but otherwise you don't have any conditions. Because what the law says is that when I don't find probable cause on a new charge, you're entitled to be released, but I do not dismiss cases. The county attorney can still go forward on this, which is why I gave you a lawyer and I gave you some court dates. Otherwise, you're going to get released.
So I'm getting OR?
No, I guess I'm saying it's not even OR.
Yeah,
you're just released.
Right.
You don't have to promise me anything. You're just released. OR is your promise to do things. You don't have to promise anything. I didn't find probable cause.
Okay,
I'm just telling you, your
saying.
terms and conditions always require. You call your PO within 72 hours of release.
Okay.
I click the button on everything because it prints the phone number. Then you have no excuse. You can't come, you didn't know my PO's number. Yeah, you did. I gave you the main number. So just do it. And smart people, when this happens, they call their PO and they get right with their PO.
Because I've been doing good for 13 months.
You need to keep doing good. Be upfront with your PO. Be straight with your PO because this is a temporary situation.
Yeah.
I would stake my life about what these drug results are going to be, but it's not probable cause. It doesn't matter what I personally think. It matters whether the police met the standard. They did not. You are entitled to be released. So get right with your PO. That is the best thing you can do for yourself while this goes through the system. They may well wait for lab results and you don't end up charged for 6 months in this case. The best thing you can do in that situation is be good on probation. So that's sort of life advice, not legal advice. All right, everything's on your paperwork. I did give you a lawyer. I gave you some court dates. Just don't lose it. Call your PO when you get out. They'll help you keep track of your court dates, and everything's on your paperwork.
Thank you.
No problem. Mr. Bender? Hello, sir. Can I have your full name and your date of birth? What's your name, sir?
Robert Bender,
What's your date?
32983.
Okay, thanks. Oh, Mr. Bender, I just saw that you have a DOC hold. Okay. All right. You got arrested for possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. I'm going to give you a lawyer and a couple of court dates. The first one is a status conference, October 16th. That's 2 weeks from now, 8:30 in the morning. Your preliminary hearing will be October 20th. I did not find probable cause in your case either, which means the police did not provide enough support for the allegation that what you had was narcotic drugs. The case is not dismissed, but I must release you. I just saw that you have a DOC hold though. So what's going to happen is DOC is going to get notified that you got released. They will get 24 hours to pick you up. If they do, then you deal with them. If they don't pick you up and you hit the street, don't miss your court dates. It's all going to be on your paperwork because the case is not dismissed. I just have to release you because I didn't find probable cause for the drug.
Okay, can I ask a question?
Sure.
What do you mean by you don't find probable cause?
Oh, it means that, so the police have to give me a minimum amount, it's kind of specific, to establish that what you had was, they're alleging it's powdered fentanyl, but on powder, police aren't, legally speaking, they can't look at powder and go, nah, that's fentanyl. Because sometimes it's meth, sometimes it's cocaine, sometimes it's baby powder. So they have to do a field test, there have to be some things. They didn't do that. So just like in most cases, do I think it was probably fentanyl? Yes. But they didn't meet the legal standard of proof, which means you're entitled to be released while the case moves forward. So I'm releasing you. The case is not dismissed. The county attorney can still go forward, but you are entitled to be released. Your problem is that you also have a DOC hold. So I'm releasing you in this case from this jail. The DOC is going to get a call, and they get 24 hours to come and get you. So I can't help you with that. I got nothing to do with you.
No, I do have a question with that. If DOC comes and gets me,
yes.
Okay, I go back to prison. What happens with the case when I'm in prison?
If they go forward, it's going to end up in a warrant. It'll be put on you at the prison, and they'll bring you here before you actually get out of prison. If they don't charge it yet, if they wait for lab results, which they often do, you may get out of prison before they charge it. So it just depends on when the county attorney decides to charge it.
Okay, so would I'll be bedded today?
Sorry?
Or would I be put in a bunk today?
I don't know. Talk to the DOs. I doubt it because now you've been released and they're just waiting to see if your PO comes. So I doubt you might get a mattress if you get 24 hours, but I don't think you're going to get a bed. All right, if you step to your left, you get that paper. All right. Thank you.
Okay, thank you.
Yeah, no problem. All right, Mr. or Officer, I've got Mr. Gutierrez Hernandez and Ms. Marin. As house calls, are they not physically present because they could pose a risk of danger to themselves or others?
Yes, Your Honor.
All right. I'm going to go to each of those defendants in person in-house immediately after this hearing to conduct their initial appearances in person. I will advise Atanasio Gutierrez Hernandez that he got arrested for dangerous drug possession, Class 4 felony, and drug paraphernalia possession, Class 6 felony. I did find probable cause, and I am appointing a lawyer for him. His next court date will be a status conference October 8th at 8:30 and a preliminary hearing October 10th at 8:30. And I'm inclined to set bond in his case in the amount of $500 secured for the reasons set forth in my written order. Andrea Marin, born 11/14 of 87, got arrested for aggravated assault on a correctional employee. That's a Class 5 felony. And then multiple misdemeanors. Assault, disorderly conduct, 2 counts, criminal damage, and a 3rd count of assault is a Class 3 misdemeanor. I will advise her that there is probable cause for those, and I am appointing a lawyer for her. Her status conference, provided I do release her, is going to be October 16th at 8:30 in the morning, with a preliminary hearing October 20th at 8:30. And I am going to release her to pretrial services. That's what's indicated by the risk assessment score, and it's also the state's recommendation. I believe it is appropriate. And my inclination is to order no uninvited contact with the alleged victims or parents. So I'm going to go talk to her, and it's my hope that she will understand that order and be able to indicate to me that she will comply with it. She really doesn't have any criminal history, and it's not clear to me that her parents will not want to have contact with her. I am going to order no weapons or drugs, no alcohol. She has to obey any order of protection. And again, she's not to have any uninvited contact with the alleged victims, and she can't live with them unless they consent, and that consent must be ongoing. If it's revoked or if they never give it, she has to find alternative residence and bring proof to her next court date. Alrighty, everything is going to be on the paperwork. If anything changes after I see these 2 defendants in-house, my final written order will contain the court's ultimate ruling in these cases. I am not going to update the recording. Thank you. We are in recess.